Good morning. I think we're going to go ahead and get started. I'll have Ms. Taylor check with AT&T and see if we're all set. Looks like we got a thumbs up here. Well, good morning to my fellow members and to the work group participants and the public watching. We'll have several people on Zoom and some here actually in person and live this morning. But before we start, I just want to get some introductory remarks and have Ms. Taylor please call the roll. And then we'll have her make some safety and informational announcements, and then we'll call the first item. Ms. Taylor.
Excellent. Good morning. We'll start with the roll call. Chair Lieber. Here. Vice Chair Gaines.
Here.
Member Vasquez.
Present.
Member Schaefer. Deputy Controller Emron.
Present.
A quorum is present. Our first order of business is our safety and informational announcements. Welcome to the May Lee State Office Complex. First, I would like to remind the audience to silence their cell phones and other wireless devices. Our safety announcement. In the auditorium, the exits are located on each side of the stage at the front with additional exits at the rear. Please take a moment to locate the exit sign and the closest exit to you in the event of an emergency. This board meeting will be live streamed to the public and posted on the BOE website. Public comments are taken on each agenda item. If there are any members of the public wishing to speak before the board on any agenda item in person, we ask that you complete and submit to the Sergeant-at-Arms a public comment appearance sheet located at the entrance of the auditorium. If you wish to speak before the board by telephone, please dial the phone number and access code provided on our public agenda notice and follow the instructions of the AT&T moderator. When giving public comments, please limit your remarks to 3 minutes. We also ask that all speakers in the auditorium or on the AT&T telephone line to state their names before speaking on the record. That concludes the safety and informational announcements. Thank you.
Thank you, Ms. Taylor. And I want to just, for those that might be listening or watching this on Zoom, we have everybody here present, and from my understanding, Member Schaefer will be on Zoom himself, I believe, or through Teams. I don't know what.
Yes, Member Schaefer may appear later this morning, and when he does come on to the remote Teams environment, we will need to take we don't need to take a recess, but I do need to ask him a question before he joins. So I'll let you know.
Thank you. I want to welcome everyone as we convene the third meeting of the AAB and Assessors Issues Board Work Group. We have a dozen participant and officers represented here today, many of whom are returning back from some of our previous meetings to discuss 3 topics, and we look forward to their insight and perspectives. Before we start this first panel, I want to make a few comments about the work group and how the meetings have been going so far. The first 2 meetings of the work group resulted in a significant amount of testimony and knowledge sharing from the assessors and the various parties involved in the assessment appeals process. The discussions have addressed a wide variety of issues and have created administrative delays for assessors and AABs, including the assessment appeals process and the refund process. The incorporation of new technology into these processes and the administrative impact of Prop 19. As a result of these work group meetings, the board has, among other outcomes, 3 of the following, which I'll mention here: extended existing educational materials to the county clerks and the AAB members. 2, approved and published guidance in response to specific issues and concerns. And 3, identified issues which would require legislative change or long-term commitment and collaboration while deepening our understanding of those issues and engaging with relevant stakeholders. We greatly appreciate the contributions of our participants, the executive director, the agency staff, and everyone involved who have contributed to the success of this work group so far. And we are hopeful that the specific topics for today's meeting can lead to additional concrete outcomes to assist in the work group goals. Topics for today. In light of the testimony gathered at the first two meetings, the work group has decided to focus on three specific topics at this meeting today. To facilitate the fullest discussion at today's meeting, I have provided descriptions of the topics in PAN materials, which all members were provided. These topics consist of possible ideas and suggestions which would have arisen to address administrative concerns, but which require additional input from all parties. The topics for today consist of: 1, possible amendments to the assessment appeals application form. Work group testimony established that the form as currently constituted may create confusion for taxpayers, which in turn can create administrative burdens for counties as they work to resolve appeals and issue refunds. Our hope is that the testimony today can identify sections of the form which can be improved, as well as areas of consensus to begin a possible reconsideration of parts of the assessment appeals form if appropriate. 2, possible BOE guidance on factors for AABs to consider in the making decisions on postponements and continuance of cases. Work group testimony established that the continual granting of postponements or continuance can create backlogs in the scheduling of the AAB matters. The concept of good or reasonable cause for a postponement or continuance is a legal term, and not all AAB members have a legal background, and counties have varying levels of immediate access to county, council, or AAB hearings. One work group participant proposed a list of AAB-specific factors to be considered in making these decisions. This list can be found in the PAN materials. My hope is that by receiving input on these factors from the participants, that areas of consensus can form the basis for new guidance aimed at helping AAB members identify when the postponement or continuance is not as likely not justified. 3, possible BOE guidance on encouraging scheduling coordination between assessors and AABs. Work group testimony established that the appeal scheduling practices can create administrative burdens on the AAB process. As both county assessors and AAB clerks are involved in every appeal in different roles, it is important for the relevant parties to coordinate or communicate to certain extent. One work group participant proposed revised guidance from the BOE to encourage greater cooperation between county clerks and assessors to reduce or minimize administrative barriers. Our hope is that by receiving input on this proposed language from the participants, we can find areas of consensus for the BOE to encourage the optimal level of scheduling coordination between the county clerk and the assessor. Proceedings. Regarding the format of the meeting, we have 3 panels of participants who will be presenting today. First one will be county clerks and AABs. The second one will be the county assessors. And the third one will be taxpayer organizations. We will receive a mix of remote and person testimony. Each panel will begin with the participants given an 8 to 10 minute presentation on all 3 topics, dividing their time between the topics as they prefer. Once all panels participants have presented, there will be a time for board discussion and Q&A, followed by the time for public comment. My goal is that the format will be the most conducive to a fruitful discussion. As each participant, many discuss each topic, I have provided note pages with the PAM materials to assist the board members in keeping their comments and questions organized. With that, I want to thank you all again and welcome with those opening remarks. And let me turn it to my fellow colleagues and board members to see if they have any opening remarks. I'll start with our chair.
Excuse me, Member Vasquez?
Oh, yes.
I believe that Mr. Schaefer has joined the meeting.
Okay. I see him on the screen.
All right. Mr. Member Schaefer, can you hear us?
I think he's muted.
Yep.
Oh, yes, I can hear you fine, thank you.
All right, thank you. I do have a question, a statement. Member Schaefer is appearing remotely. If a member of the board attends the meeting by teleconference from a remote location, the member shall disclose whether any other individual, 18 years or older, is present in the room at the remote location with the member and the general nature of the member's relationship with any such individual. Therefore, Member Schaefer, is there anyone 18 years of age or older present in the room at your remote location?
Yes, I have Dr. Cody Pedersen in the room with me. He's my chief of staff. He's here on official business.
Thank you so much. Back to you, Mr. Vasquez.
Thank you, Ms. Taylor. With that, let me go back to my chair.
Thank you so much, Mr. Vasquez, and I wanted to extend my thanks for all of the work that you have personally put into this process, as well as your staff. I know it's been a very thorough dive into the subject matter, and I appreciate all those who have taken part in the process over the previous meetings. I've taken a lot of notes, and I think those will be very helpful as we synthesize everything that we've heard. And I know that your goal, as is mine, is really to facilitate a system that works for all taxpayers, both large and small, and to illuminate some of the issues, even where we don't strictly have jurisdiction, for example, over the clerks and collectors, but to really highlight what's happening for taxpayers in terms of review of their assessment and also in terms of getting timely refunds. So again, I thank you for presenting this to us, and I look forward to the testimony that will be provided today.
Thank you. It looks like our deputy clerk, go ahead, or controller.
Thank you, Mr. Vasquez. Good morning to you all. On behalf of our great state controller, Malia Cohen, I'm excited to be here. I think it was just about a year ago, February 2025, we decided to take this journey. So I want to thank the county representatives, taxpayer advocates, and stakeholders for joining us today. And now we're several work groups in, and I want to begin by acknowledging the depth and thoughtfulness of the testimony we have received over the past year. I found that there is a remarkable degree of consensus that while our assessment appeal system is fundamentally sound, it faces persistent operational challenges, particularly around training, application, clarity, scheduling, coordination, and the consistent application of good cause. What we have heard clearly is this: many AAB members are being asked to make complex procedural and quasi-judicial determinations without uniform statewide guidance or ongoing training. Counties are navigating scheduling coordination challenges that require balancing efficiency with neutrality, and applicants, especially self-represented taxpayers, often struggle with technical application, language that can unintentionally lead to delay or confusion. Our responsibility here as a board is not to micromanage county operation, nor is it to tilt the process one way or another towards the assessors or taxpayers. Rather, our constitutional role is to promote fairness, uniformity, and confidence in California's property tax system. That means asking the hard questions. Are delays driven by unclear standards? Are continuances being granted out of caution rather than clarity? Is information exchange occurring early enough to prevent compounding backlogs? And can better statewide guidance and training reduce unnecessary friction without limiting due process? Today's discussions is an opportunity to move from identifying challenges to considering targeted practical improvements. I look forward to hearing from each panel and continuing this collaborative effort to strengthen the integrity, efficiency, and fairness of the assessment appeals process statewide. And I want to welcome everyone here today. Thank you.
Thank you, Vice Chair.
Great. Yeah, thank you. It's great to be here and to learn. I think, number one, we want to cause no harm. So my hope is that by these gatherings that we provide some guidance, or actually, in a sense, a forum for discussion with the county assessors. And of course, the county clerks, for which we don't have jurisdiction over, but I think we can have some great discussion and hopefully come up with means of providing counties with a more efficient means of how to make sure that we're serving the needs of our constituents when it comes to an appeal coming before their boards. And so I look forward to it, and I'll be taking notes and listening, and hopefully we can come up with something that has some level of uniformity. And I know that's always a challenge when you're dealing with 58 counties. So look forward to it. And thank you for leading this effort, Member Vasquez.
Thank you. With that, let me turn it back to Ms. Taylor, and if she could please call our next item.
All right. Our next item is item number 2, panel number 1. And during this panel, they will discuss the following issues: consideration of possible recommendations on amending the assessment appeal application, developing factors for AABs to consider in good cause, reasonable cause determinations, and developing guidance on scheduling coordination between county assessors and county clerks. Did you want to introduce the speakers, or would you like me to introduce the speakers?
You know what? I'm going to ask you, because I'm looking at my notes, and I know I see Ms. Moore here present, but
Yes.
I don't know who's on remotely.
All
Or
right.
at least it's not on my notes here.
So in person, I'll ask Ann Moore, Assistant Clerk of the Board of Supervisors, San Diego County, to come forward. And I believe the rest of our participants for this panel are on teams. That is Thomas Parker, Principal Deputy County Counsel, Property Division, Office of the County Counsel, Los Angeles County. Jennifer Tran, Assistant Executive Officer, Executive Office of the Board of Supervisors, Los Angeles County. Brendan Vlachis, Chair, Assessment Appeals Subcommittee, California Clerk of the Board of Supervisors Association, and the Assistant Chief Deputy Clerk of the Board, Ventura County. And Leslie Pack, Deputy County Counsel for the Assessment Appeals Board, Santa Clara County. You are welcome to turn your cameras on and unmute, since this is a panel discussion.
Thank you, and I see Ms. Moore here in person, so why don't we go ahead and start with you first.
Good morning. I'm Ann Moore, Assistant Clerk of the Board for the County of San Diego, but I'm here to speak on behalf of the California Clerks of the Board Association. So thank you to the honorable members of the board for this opportunity. And thank you for the ongoing collaboration between the Board of Equalization and the California Clerks of the Board of Supervisors Association. We truly appreciate the thoughtful engagement that we've had with your staff over the past several weeks. We also want to express our appreciation for the collaboration of the other participants in this process, including our partners from the Assessor's Office and from CADA. We recognize that all of us, regardless of our individual roles, are working towards the same end goal: a fair, efficient, and accessible assessment appeals process that serves taxpayers well. The open dialogue over the last several weeks has been extremely valuable, and we are grateful for everyone's willingness to bring forward ideas, concerns, and practical perspectives. Members of our Assessment Appeals Subcommittee met internally after our discussions with BOE staff to evaluate the proposed concepts and language, and the comments I'm offering today reflect both that review and the practical experience of the clerk's offices across the state. I'd like to begin with topic 1, which is the amendments to the assessment appeals application, because the application is one of the documents that every applicant must interact with, and sections 5 and 6 continue to be the most common areas where taxpayers struggle. Across county, clerks consistently see the same patterns. Applicants check too many boxes, or not enough boxes, or boxes that can't be checked together, or they select a reason that doesn't match the assessment they're appealing. And these issues overwhelmingly stem from confusion, not carelessness. I also want to share something anecdotally that emerged during our subcommittee's own review. When we sat down as a group and walked through certain filing scenarios, even our most experienced appeals clerk did not always agree on how sections 5 and 6 are meant to be interpreted. If the people processing these forms every day can reasonably arrive at different interpretations, it's no surprise that applicants struggle. This is exactly why CCBSA strongly supports expanding and clarifying the inline instructions within these sections. Our recommendation is to embed plain language guidance directly into sections 5 and 6, so filers can more readily understand the type of assessment they're appealing and the specific reason for their appeal. Improving clarity at the point of selection will significantly improve accuracy for first-time filers, reduce administrative burdens, and help ensure that applications are complete when they're received. We also want to briefly acknowledge the idea of creating a simplified or alternative application, for example, an additional shorter form for single-family residential properties. While well-intentioned, this approach would introduce new complications. Before even filling out the application, applicants would now need to determine which form applies to them, and counties, particularly those using custom software, would face substantial costs and operational challenges to support multiple application pathways. The length of the application isn't the issue. The instructions and applicants' understanding is, and that's where targeted improvement will be most efficient and most impactful. Touching on good cause determinations, we appreciate the work BOE staff has done to develop potential guidance. We believe that the clear, structured advisory set of factors will be extremely helpful to AAB members, particularly those without legal training. Many AAB members are skilled professionals, appraisers, accountants, and real estate experts, but as we've discussed before, good cause determinations often involve legal analysis, procedural judgment, and consideration of statutory timelines. A well-crafted framework will support greater consistency and confidence in these decisions across counties. That said, guidance must remain flexible. Every appeal is different, and AABs must retain discretion consistent with their quasi-judicial role. We have recommended 2 clarifications: acknowledging the county's specific considerations and reinforcing alignment with Property Tax Rule 323. These suggestions ensure the guidance remains practical, legally grounded, and sensitive to the differing needs and resources across counties. Overall, we see this as a strong resource that supports AAB members while still preserving the necessary case-by-case discretion. And then finally, I'd like to address scheduling coordination. Clerks manage scheduling with great care, balancing assessor availability, appellant schedules, statutory timelines, hearing officer calendars, and county staffing resources, often simultaneously. We've reviewed the proposed language from BOE staff regarding assessor scheduling needs, and we have significant concerns with making this a mandate. Clerks already coordinate with assessors as a practical matter. We understand and respect that assessors face the same staffing and resource challenges that we do. And in many counties, the working relationship between the clerk's office and the assessor's office is excellent. However, requiring clerks through guidance or rule to prioritize assessor preferences risks undermining the clerk's neutrality. If assessor preferences are mandated, professional tax agents will understandably request equal consideration, and applicants may do the same. That scenario places the clerk in the difficult position of arbitrating between multiple competing interests, which is precisely what leads to delays and administrative strain. We also want to reiterate that the existing guidance is already sufficient. LTA 2013-039 and Property Tax Rules 307 and 323 provide clear, long-standing direction on calendar management. If the board determines that further clarification is necessary, we respectfully recommend using permissive language such as may take into account rather than mandatory language such as must or shall. This preserves the clerk's office ability to manage calendars in a way that reflects the most pertinent factors for their particular county while still recognizing that the coordination with the assessors can be appropriate when circumstances allow. Across all 3 topics, our focus is grounded in the same principles: improve taxpayer understanding and reduce confusion, strengthen statewide consistency, protect the neutrality of the clerk's office, and avoid unintentional operation or technological burdens. We deeply appreciate the opportunity to participate in this process and the thoughtful engagement from BOE staff, the assessor's office, and CADA. CCPSA remains committed to working collaboratively with all of our partners to improve the assessment appeals process in a way that benefits taxpayers and counties alike. And one final thing that I'd like to add from my role as Assistant Clerk of the Board in San Diego County, I want to thank your team's work on an item that isn't on the agenda. The recently published LTA clarifying e-signature guidance has been tremendously helpful in moving forward conversations with our county council on implementing e-signatures. So we want to express our appreciation for that. Thank you very much for your time today. We appreciate it.
Thank you. Now that I found my notes going back, and I know we have online right now, is from the AAB's county clerks, which is Mr. Parker, who has provided testimony before us several times, especially on this work group. It's been very valuable and very helpful, and I see him on the screen. So, Mr. Thomas Parker, if you, oh, I'm sorry, go ahead.
I'm sorry, Yvette Stowers, Executive Director. I just wanted to correct the record. This is a work group, so you've been interacting with not BOE staff, but the member staff, except for the LTA. Just wanted to correct the record on that.
Thank you.
Just a question of clarity.
On-
Can we ask questions?
Yes, what I was trying to do is, after all the panelists speak, we'll do the Q&A. I'll
Okay.
turn it over to you
Very good.
folks.
All right,
If you
thank
could
you.
just keep note of, make
Okay.
note of anything you have.
Sure.
And I see Thomas Parker on the screen. If you want to go ahead and start with your remarks or comments.
Thank you, Mr. Vasquez, and honored members of the State Board of Equalization. Thank you for, as well, on behalf of the CCBSA, for your efforts to try and improve the process for everyone involved in it. I certainly endorse everything Ms. Moore just related to you as a representative of the CCBSA. I would just try and add a little bit of gloss, if I could use that term. Regarding amendments, I think I certainly agree that to some degree, it's unavoidable, but hopefully there is some of it that can be avoided. The technical language in the appeal application regarding sections 5 and 6. I think I would add as well that whatever changes to 5 and 6 come out, we need to make sure that we are merely clarifying in plain language, or as plain as possible, the intent behind sections 5 and 6 of the current application form. Because anytime you make changes, the law of unintended consequences might create new challenges for future applicants and future clerks down, and maybe even assessors' offices down the road. So we definitely need clarifying language. We need to make sure that we don't create unintended consequences to the extent that we can foresee the future with our broken crystal balls that we all work with. Regarding topic 2, it's always good to have guidance, suggestions, not mandatory, but suggesting guidance for good cause, good/reasonable cause regarding postponements and continuances. It's a very fluid situation and with continuances and postponements. By that, I mean the nature of the appeal, that is, say, the property, the amount of money at issue, the type of information, and the amount of information needed in order to have a fully informed assessment appeals board meeting is going to vary from case to case, from a practical viewpoint as well as from a legal viewpoint. And I would the greater the and I, as a lawyer, think it's important in any additional guidance that the state board might include on when continuances or postponements ought to be granted is being considered. It is important to acknowledge in that guidance Rule 323, so that, which has been on the books for some years now, and just to make sure that everybody doesn't forget that inadvertently. Regarding schedule coordination, That's a really interesting balancing act in my view. I've been both assessor's counsel for 16 years, and I am now entering my 16th year as an AAB counsel for one county or another. I give that just as context for saying that your assessment appeals board manual properly notes that there should be some degree of consultation between the county clerks and the auditor's office. And that's based on a very practical and important consideration, which is the assessor is a party in every appeal. Not every private party is a party in every appeal that the AAB is going to hear over the years. But it is also important to balance with that what Ms. Moore said earlier in her comments. That is to say, this is a quasi-judicial proceeding. AABs must be objective and neutral, not only in considering the evidence that is being presented and weighed by the AAB, but also in terms of the scheduling. Because an AAB hearing is only as good in many ways as how well informed it is in terms of the evidence presented to it. Just like computers, if you put bad information in a computer, you get a bad computer result. AABs, in my view, are much the same. If the AABs don't have all the relevant information in order to make an informed decision, the decision may not be the best decision. But that, to me, is not the fault of the AAB itself. It's the fact that they didn't have all the information available from both sides to be presented, to be cross-examined, and then to be weighed by the AAB. So continuances and postponements have been built into this system since the 1960s, and they are important aspects of the system. They should not drive the system in and of themselves. But this, in my view, is a tricky balancing act. And therefore, we need to be careful about, as Ms. Moore mentioned, always recognizing that as a quasi-judicial body, the AAB has to weigh postponement and continuance requests in light of the context of the particular appeal. And to conclude on schedule coordinating, I digressed a little bit. I apologize to the board. The scheduling coordination is a three-party process in many ways. But the ultimate decision, as I have urged many times upon the State Board of Equalization, it's ultimately up to the AAB as a matter of law to decide when things get scheduled, as well as whether they're virtual or in person. And so the AAB is the party that ultimately has to balance the scheduling needs of appellants and the assessor's office. And I'm glad to take any questions later on at the appropriate time. Thank you.
Thank you. And let me go with our second speaker, which is Jennifer Tran, who's also from the LA County Board of Supervisors. Ms. Tran has also participated in previous meetings and has brought data focused perspectives on the AAB process in LA County. And I see her on the screen. If I could just have you go ahead and open up with your comments and remarks. Welcome, Ms. Tran.
Thank you. Good morning, honorable members of the board. My name is Jennifer Tran, Assistant Executive Officer for LA County Board of Supervisors Executive Office. On behalf of our Executive Officer, Mr. Edward Yen, I thank you for this honor to speak with you today and the opportunity to provide feedback and recommendations to help improve the assessment appeals process. On the topic of amendments to the assessment appeal application, Last fiscal year, LA County received nearly 18,000 assessment appeals applications, of which 55% were filed manually and 45% were filed online. We recently conducted a time study on the online submission process and discovered that on average, an applicant without agent representation would take approximately 15 minutes to complete and submit their online application. During the same fiscal year, we also received nearly 2,600 telephone inquiries, of which 5% were calls with questions on key terminologies listed on the application, including the type of assessment being appealed under Section 5 and reason for filing an appeal under Section 6. Therefore, LA County AAB has the following recommendations for your consideration. First, use plain and simple language with key terms and definitions on the instructions on how to complete and file an appeal to avoid confusion. It is also recommended to include a high-level overview of the appeals process. Second, place the information and instructions for assessment appeal application at the front or before the application form itself to provide clear and upfront guidance that will help reduce mistakes and incomplete submissions. Additionally, having the instructions at the front of the form will also help the applicants determine if they would prefer to file the appeal themselves or to obtain professional tax agents to file the appeal on their behalf. However, while LA County is still exploring finding a solution to replace or enhance our legacy system, any changes on the application's fields or questions will require additional resources to redesign and reprogram our current system, which may be challenging due to our current budgetary constraints. As such, it will be more beneficial to revise and improve the instructions rather than changing the application's fields or questions. However, if the state board decides to pursue changing the application's content, we would like to present the following suggestions for consideration. First, on the applicant information under Section 1, we recommend adding the preferred method of contact, for instance, mail or email, to receive their correspondence or notification. Second, on the contact information, agent, attorney, or relative of the applicant under Section 2, we suggest adding a checkbox to identify the relationship to the applicant, such as agent, lawyer, corporate officer, or relative. Lastly, the claim for refund question should be placed after Section 2 to help minimize erroneously skipping or unmarking of this section. On the topic of factors for AEBs to consider in good or reasonable cost determinations, during last fiscal year, 24% from nearly 36,000 scheduled applications were postponed, which already represents a 33% decrease in postponement requests compared to fiscal year 2022-23 that can be contributed to our hybrid appeals hearing platform. In LA County, the postponement request form can be submitted manually or online. As such, we respectfully recommend to the board to implement a statewide postponement request form to create consistency in format and application of rules and requirements, including a certification section to certify that the information is true and correct under the penalty of perjury. Lastly, LA County agrees with the proposed language listing the facts and circumstances that the AABs may consider when granting postponements and continuances. On the topic of development of guidance on scheduling coordination between assessors and county clerks, as I shared from prior testimonies, the scheduling coordination and collaboration between the AAB and the assessor's office has greatly contributed to the dramatic closure of LA County's backlog appeals. However, I would like to emphasize that AAB maintains full control over scheduling. We regularly meet with the assessor to prioritize the scheduling of appeals based on AAB's data or analytics, which may include open appeals based on property type, type of issues appealed on, and region. Additionally, AAB shares open, scheduled, and closed appeals information to the assessor through an automated data interface on a nightly cycle. However, please note that one size does not fit all, since each county has its own workload and unique needs to consider. As such, we respectfully recommend that if the board decides to establish additional guidelines to property tax rules 307 and 323, it will be beneficial to use discretionary language that will provide the AABs the flexibility to determine the approach that is appropriate to their operational needs. And this concludes my presentation. Again, thank you for allowing me to address your board. I appreciate your time and the opportunity to share LA County AAB's perspective. Thank you.
Thank you. And we'll come back to you with, I know we have some comments and questions, but let me move on to our third speaker, which, and looking at my notes, I guess I was supposed to combine it with Ms. Moore. So let me, and I see, I think Brandon is on the screen. I see him up there as well.
Yes.
Velakis, he's the chair of the subcommittee, California clerk of the Board of Supervisors Association, and assistant chief deputy clerk of the Board of Ventura County. I wanted to also mention, and he has committed a great deal of time and work to this work group and has been very helpful in allowing our work group to connect with the county clerks on these important issues. My understanding that the next speaker, which was going to be combined with the two, we've already heard from Ann Moore, so let me open it up to Brendan, if you can go ahead and give us your comments and suggestions.
Thank you. I'll be brief. Good morning, members of the Board of Equalization. I'm Brendan Vlahakis, participating today on behalf of the California Clerk of the Board of Supervisors Association. As stated by my co-chair, Ann Moore, she is serving as our representative this morning. I remain available should you have any questions, but will primarily defer to Ms. Moore as CCBSA's representative for today's proceedings. Thank you.
Thank you. With that, let me move on to our fifth speaker, which is Leslie Pack. I think I see her on the screen as well. Deputy County Counsel for the Assessment Appeals Board from Santa Clara. And first of all, she's here actually from the AAB from Santa Clara County. While this is Ms. Pack's first time on our work group, it is not the first time that we've heard from the County Council from Santa Clara. They have been providing thoughtful and important input at our previous meetings. So welcome, Ms. Pack. I know you've had some big shoes to fill over there in Santa Clara and really appreciate you joining us today. We'll turn it over to you.
Thank you. Good morning, honorable members of the State Board of Equalization. Thank you for the introduction and for the opportunity to participate in today's work group. I will be addressing all three topics today, starting with the potential amendments to the assessment appeals application. To address the issues that are often raised by the application, the hearing clerks in my county have assembled a list of common areas of confusion among applicants related to the application. To stay within my allotted time today, I'll just share a few examples from that list, but I would be happy to submit the full list if the board would like to see it. Some of the examples that the clerks have identified are items that are already addressed in the application instructions, but still raise questions among applicants. And so we believe that for these issues, the instructions could be fleshed out to provide more of an explanation to address the most frequent misunderstandings. As an example, in section 4, where applicants can list their enrolled values or opinions of value, the instructions advise them that they need to list the values from the assessment notice or tax bill that they're appealing on. But applicants sometimes don't understand what the term improvements means and think that they are being assessed for construction they haven't done and file new construction appeals. Similarly, in section 6, where applicants can check off their reasons for filing an appeal, there are options to appeal the assessor's classification of their property or the allocation of their property's values. And these boxes often get checked because applicants don't often know what the term classification or allocation means with respect to their assessments. And so they check those boxes to avoid waiving any claims that they may be eligible for. Also in section 8, where applicants can designate their applications as a claim for refund, the instructions do explain that refund claims affect the time period for filing suit in Superior Court, but it could be clearer within the instructions that the claim for refund does not affect whether applicants will obtain a refund of their property taxes if the AAB decides in their favor. So those are a few areas where the existing instructions could potentially be fleshed out some more. In addition, there are some issues that are not addressed by the instructions currently. One of those has to do with personal property appeals. Our hearing clerks often get questions from applicants, including agents, about whether they need to check the box in section 6 to appeal a decline in value or to appeal the assessor's valuation of their personal property and or fixtures, which is a separate issue in section 6 to check. Another issue in section 6 that applicants often don't understand is construction in progress. They often don't know how construction in progress is assessed. So when they intend to appeal the base year value of their new construction, they often add selection in progress just to cover their bases. So these are just a few examples of areas where some additions and clarifications to the instructions could be helpful. But we realize that additions to and clarifications of the instructions have to be balanced against an interest to avoid cluttering the instructions. Because we've also found that sometimes applicants don't read the instructions, and that may be because they are discouraged to see a large volume of fine print and perhaps would be more likely to read the instructions if they were shorter and in larger print. So to that end, one suggestion we have is to review the form and instructions for some less useful content that could be removed. So as an example, within my county, the clerks often actually do not need a bill number, assessment number, or DBA from the applicant for purposes of processing applications. And if that's true of other counties, then removing those fields and fields like it could create space on the application to move some of the more critical instructions from the attachment onto the main body of the form, where they would be less likely to be overlooked. An example of that would be the instructions to penalty abatement appeals. Currently, the instructions are pretty clear that penalties levied by the tax collector cannot be appealed to the AAB, but we still receive appeals for late payment penalties. And so moving the instructions concerning those abatement appeals onto the main body of the form could help reduce the number of applications that our clerks have to review and ultimately reject. Moving on to the issue of good cause and reasonable cause for postponements and continuances, we are generally in agreement with the proposed guidance, assuming that it's advisory rather than mandatory. And we have 3 additional considerations to suggest in terms of what AABs can take into account in determining good cause or reasonable cause. The first is the applicant's willingness to waive the 2-year limitation to hear appeals. Currently, under Property Tax Rule 323, waivers of this limitation period are mandatory under certain circumstances, such as when an applicant postpones for the first time within 120 days of the period's expiration. But we believe it would also be appropriate to consider the applicant's willingness to sign a waiver in instances when the board has more discretion to allow a postponement or continuance. We also suggest adding a consideration of whether a postponement or continuance will allow either party to provide information that the board determines is necessary or appropriate for purposes of deciding the appeal. And third, we suggest adding a consideration of the reasonable needs of the Assessment Appeals Board or hearing officer. Currently under Rule 23, this is a basis for allowing a continuance for longer than 90 days. And we believe it should also be a factor to determine reasonable cause for a continuance more generally. And finally, concerning scheduling coordination between assessors and county clerks, my county's clerk of the board has provided a written submittal. But because of the timing of that submittal, I would like to provide a high-level overview of their comments. Specifically, they were addressing the proposed guidance to consider the assessor's staffing levels and workload when scheduling appeals and to adopt the assessor's recommended hearing dates whenever feasible, provided that the schedule does not create a prejudicial pattern in favor of the assessor's office. So the remarks from our clerk of the board note that considering the assessor's staffing levels and workload is not feasible for them. Currently, the way that the scheduling process works is the assessor's office provides the clerk of the board with the months in which they will be ready for hearing, and the clerk of the board takes this date into account along with other factors, including the type of property at issue under the appeal, whether applicant has opted for a hearing officer, whether there are other pending appeals for the same property and which boards those are scheduled before, and which boards and hearing officers have heard appeals of the same property in the past. So these are just a few examples of what they have to take into account, and they're doing this for thousands of cases a year, and they do not have the staffing levels to also factor in the assessor's schedules and workloads. They also note, as have other speakers, that the clerk is a neutral third-party administrator of the assessment appeals process, and they are not able to afford the same level of consideration requested by the proposed guidance to applicants when appeals are being scheduled. Applicants are not given the opportunity to recommend hearing dates, so deferring to the assessor's recommended hearing dates would inherently give an advantage to the assessor. Another point raised by the clerk submittal is that although the proposed guidance is intended to address prejudicial patterns that may emerge, the clerk of the board has no way to detect or prove that a prejudicial pattern actually exists. Again, the clerks handle a large volume of appeals, and for any given appeal, there is a range of potential outcomes, as well as multiple potential reasons to favor one panel or hearing officer over others. So given all this data, determining whether a prejudicial pattern exists would require analytics that the clerk of the board does not have access to. In addition, if they cannot schedule appeals at their own discretion or even randomly, there's no baseline for comparison to see if a prejudicial pattern exists. So therefore, however unlikely it would be that staff would attempt to abuse the proposed scheduling process, the reality is there would be no meaningful checks on that process. And so for those reasons, our clerk has respectfully objected to the proposed guidance regarding scheduling coordination. And that concludes my remarks, and I'm happy to take questions during the allotted question period.
Thank you. And thank you for your presentation, Ms. Spock. And before I move on to my questions, I understand that Mavani, who contributed to our past work group meetings, was recently appointed as the court commissioner in your county. Please extend the work group's congratulations to Mr. Mavani if you have the opportunity down the road.
Certainly, I will do that, sir.
Thank you. Let me start, first of all, thank all the folks for their comments and suggestions that we received today. I have several questions. I'm just going to start with two, and then I'll turn it over to the members. And if they don't address some of the other issues I have or concerns or comments, I will bring them back. The two that I want to raise, and this is for any one of the speakers, including Ms. Moore here present, is on the topics on the AAB application for the refund and the simplification. Some of you kind of touched on it in your remarks, but on the refund, one of the original 4 work group topics, which was exploring ways to improve the efficiency of the refund process following a successful appeal, to the extent that the appeal application itself may not be the right place to gather more information about the possible refund, when do you believe would be the best place in that process to consolidate the necessary information? And I open it up to any one of the speakers.
Mr. Vasquez and members of the board, I'll take a shot at that one.
Thank you. Go ahead, Mr. Parker.
I would say that over time, information can change. What I mean by that more concretely is we have had appeals, certainly in Los Angeles, where a business entity was owned by a certain number of shareholders or individuals when they filed the appeal. But by the time the dust settles and the appeals process has said, yes, there is a refund of whatever amount of money due, ownership of the property has changed hands. And the AAB is not in a great position to note the change of ownership between the filing of the appeal application and when the resolution of that is done, such that the auditor controller is now potentially processing refunds. So that is a very practical issue in terms of, I cite that as an example and to show you that the AAB is not necessarily in a great position where it is to know down the road which party is going to get the refund of whatever amount and who that party should be. And you run as well into the problem if you try and beef up the application in some way to obtain more information up front, which is logical in some ways. Now you're potentially making the application more complex, and that's not what the CCBSA is recommending to the state board for the reasons we've all stated. It might be helpful if there was some guidance that could encourage parties who are appealing, whether they're personal or business, to put a sort of a duty or obligation on them to update the county. And I'm not sure which office it should be, but maybe the assessor, for instance. And the assessor may or may not agree, I don't know, but I'll pick on them for a moment. To inform the county through the assessor's office that something has changed, such that if there is a refund 2 years down the road, the county will know that who the refund should go to and have an address and a name. That's one possible thing to at least think about. But we want to be careful in terms of the application, not to treat the application as the means to necessarily address your concerns, sir. That's my view anyway.
Thank you. And it sounds like Ms. Moore has something to add to that.
Yeah, I would like to agree. I don't think our discussions, we had a specific suggestion on how to address this, but generally, we have a lot of complex appeals that take 2+ years. And so I don't think that the data collected at the application point is really the best way to collect that.
Thank you. My second one was on the simplification. I understand that the confusion can arise when taxpayers know they have a Prop 19 issue, but they don't know how that translates to the appeal form. To what extent would Prop 19 justify a reevaluation of the appeal application form sections to assist taxpayers in completing the form more efficiently? It looks like Ms. Moore wants to weigh in. Go ahead.
I mean, overall, your average tax payer does not know what Prop 19 means. And so when we throw around language like that, in addition to the already complex, which box do I check in 5, and therefore which box do I check in 6, I think overall, plain language, they need to understand what they're looking at. So it's the same recommendation. We need to be able to explain to our taxpayers what exactly they're needing to select for each appeal type.
Thank you. Madam Chair, go ahead.
Thank you. I have a question for Ms. Moore. You said that my understanding of what you said was that the application can't carry the weight of correct contact information over time. And so how would that correct contact information be communicated going forward?
We ask our, filers to update over time, notify us. I mean, if you're going to move or somebody is going to step in and we're going to notice you, we obviously need the correct contact information to make sure that you get your hearing notice within, statutory guidelines. So the expectation is similar. If there's, a differentiation or something changes along the course, you need to notify the clerk's office. And I think this is a similar circumstance. So I don't know if the BOE wants to move forward on a separate form, or whether it's just, like Mr. Parker said, a duty of notifying the clerk's office. We can't easily track down updated contact information, and so it needs to be on the parties to let us know.
And so how exactly do people update their information, or say that it's a business and people are cycling in and out? How do they mechanically do that?
Currently, we get phone calls, emails, letters. I mean, it's a variety of different ways. When they don't notify us and we get return notices, we do our best based on the information that USPS provides us. But oftentimes, if it says undeliverable and there's no additional information, we're at a loss. And so, at least from hearing perspectives, they end up coming down later on a validity hearing because we've dismissed it for non-appearance. So it's up to them to notify us, and we take that update in any way that they provide it.
Mm-hmm. And then I would assume that after a certain period of time, any refund would be escheated to the state and would be waiting for that person or that entity in some way.
And I actually can't speak to that because once we do our, final orders, we pass it off to the assessor's office, and then it goes to, the TTC and the auditor and controller. And so I think they'd be better to speak to that point.
Okay, thank you.
I believe that Ms. Tran has her hand up.
Thank
go
you
ahead.
so much. Thank you so much. I just wanted to add to what Mr. Parker mentioned with regards to claim of refund. So last year, as I previously shared on my prior testimony, our LA County Board of Supervisors made a motion on directing the property tax departments to do an analysis on how we can streamline the appeals and refund process. Currently, we are making a lot of progress with regards to streamlining the appeals and of course the refund process. But one of the action that we are currently working on right now is with regards to payment records. So our plan right now, or we are trying to explore the possibility of creating an interface file transfer to TTC to let the TTC be aware or know with regards to payments or properties that have open appeals or pending open appeals, to exempt those tax payment records to their record retention policy, since the property or the tax payment actually has an open appeal with AAB. I just wanted to add that.
Thank you. With that, let me go to Vice Chair Gaines. I believe you had some questions as well.
Yeah, that's great. Yeah, thank you. I was just wondering if Thomas Parker, to just provide a little more clarity. You had mentioned in your introductory comments about the quasi-judicial nature of an AAB hearing, and therefore the scheduling ought to be prioritized with the clerks. And so I just was wondering, can you expand on that a little bit? And since you've kind of represented both assessors and appeals boards, what is the issue or the pushback coming from an assessor in that statement that you made?
I'll be glad, Mr. Gaines, to respond. The pushback comes from who's ready and who's not ready in terms from both sides, applicants as well as assessors. How ready are they or unready are they to present their case? Given all the work, if you look at the assessor side for just a second, assessors' offices don't exist, of course, just to handle appeals. There's all the work that they do that lead to the assessments that may lead to a challenged assessment at the end of that particular process. And so assessors, since they have to produce the roll every year and they have to track and chart new construction, and they have to send out escape assessments when they discover there's previously unassessed property. All that is, run-of-the-mill work, and on top of that, assessors have to then defend their challenged assessments in the AAB process. Applicants, on the other hand, it may be a very, as Chris O'Neill likes to say, complex appeal. And maybe it's a huge office building in downtown Sacramento. And there's a lot of money at issue, a lot of information to be prepared, appraisals, income approach, what have you. If the applicant wants to be ready in order to present their case properly, and if they're not ready, they are certainly in Los Angeles, they're not afraid to, one way or another, tell the AAB system that they need more time. And I'm sure they tell the assessor that too, but I'm guessing, I'm not a party to those conversations. So that's kind of the pushback there. Now, as far as the use of the term quasi-judicial, the California Supreme Court, in a number of published cases, as have intermediate appellate courts in a number of published appellate cases, used the term quasi-judicial administrative hearings, end quote. Now, let's talk plain English. What the heck does that mean? That means that assessment appeal boards are granted by the Constitution the authority to interpret law and regulations, apply those laws and regulations, and determine facts from evidence submitted, just like a superior court would. So that is what they mean by quasi-judicial administrative. And what's that mean? That means that courts, everyone knows this, but at the risk of saying the obvious, courts have to treat both parties in front of them equally and impartially, apply the laws, make the factual determinations necessary to resolve the dispute, and render a decision. And that's what, in the property tax context, the Constitution assigns to assessment appeal boards or local boards of equalization where you don't have an AAB ordinance. And so that's what I mean by quasi-judicial. If I haven't been clear enough, Mr. Gaines, please let me know and I'll make another attempt to be plainer as I need to be.
No, that's excellent. Thank you. I appreciate that. And you had also mentioned that there could be unintended consequences of changing the application. But we've had some recommendations given for changing the application. So I'm just trying to wrestle with that in my mind. Do you create additional litigation by trying to provide clarity for an applicant filling out an application?
No, sir. No, sir. And let me clarify my reference to unintended consequences. Clarification, simplification, whatever word is the best word to use, is good. And it better informs the applicants as well as agents and say attorneys who are not as familiar with the property tax world as others might be. But we want to be careful not to go beyond simplification and say, well, while we're amending this application form in the name of simplification, let's not add more to it. Because we have the opportunity here, right? This is a vehicle that it could happen. For instance, adding additional information that is going to confuse parties.
Okay.
So that's
helps.
my point.
That's great. Thank you. And then if I could, just a question of Ann Moore in terms of the prioritization for scheduling lies with the clerk. How's that working with the assessor in terms of coordination?
Well, in our county, we have a really close relationship with the assessor's office. And to give you a little background, before joining the clerk of the board, I spent 11 years in court administration in King County in Washington State. So I have a lot of experience in calendar management. We work very closely, and I'm speaking from San Diego's perspective, with the assessor's office on availability, on understanding, in our current situation, we know which assessors are generally handle which type of cases, and we try to group those and schedule those in a way. But if it comes down to the assessor wants a specific day and the party just wants a specific day and they don't match, that's not something that we can weigh and determine who's right and who's wrong. So it's really, when they notify us that they're ready to go on this hearing, we already have kind of an expectation of what hearings are going to be heard when, as far as hearing types, commercial versus residential, et cetera. And we try to work around that. But at the end of the day, it's, we're at a 2-year time frame. Our party's ready. We need to proceed. And so we as clerks need to be able to manage our calendars so that we can get people to done as quickly as possible, because that's really what the taxpayers are looking for.
Mm-hmm. Okay, good. So Assessor Marks works with you, and
We have a very good relationship with our assessor, yes.
yeah, very good. Great, thank you. Appreciate it.
Chair, I'll ask a follow-up question. I don't know if go ahead.
Yeah, thank you. Well, it's a question for our executive director. I know that within the agency, there's a forms review process, and I'm wondering, have these 2 questions on the intake form come up there?
Good morning, Chair Lieber. David Young, Deputy Director of the Property Tax Department. You are correct. We review all our forms every single year. We just sent out our initial letter contacting county assessors and our partners in review, and we actually do look at the assessment appeals form. And I personally have taken a look at section 5 and 6.
Okay, and has the determination coming from the agency been that it's sufficiently simplified, or does it need work?
We're always looking for additional improvement, anything that would make the process easier, more clear. We're always looking for incremental improvements.
And so the plain language would be generated by the forms working group?
Ultimately, we would propose an amendment if there is one. We take in all the comments that we get in our review, and of course, the testimony that's happening right now. We take all that in.
Great, and is moving the instructions to the front rather than the last pages of the form, is that a non-controversial change?
It's less controversial if all you're doing is moving it front to back. There is, and the point has already been brought out, there is a cost-benefit analysis into how much you change the form, how much longer you change, how much longer the form becomes, how truly thick that instruction is at the end. At a certain point, some of the changes can outweigh some of the benefits. It's just a whole lot of folks, when they get that, sometimes that initial feeling of looking at a 15-page form may actually be enough to sway some folks. So we do take all that into consideration. We're trying to be as judicial as possible, weighing the cost and the benefits. And of course, we're also very aware that when we change a form, there are administrative costs to our partners in changing it. For some counties, it's easily absorbed. For others, it could be quite a challenge.
Okay, thank you.
Of course.
Member Vasquez?
Yes, how
Mr.
we doing on?
We're doing fine on time, but Mr. Schaefer has his hand raised.
Oh, okay. And then we'll go to our deputy clerk, our controller here. Go ahead, Mr. Schaefer.
Yes, there's some discussion about refunds being made available, and maybe some difficulty in locating the property taxpayer. I would assume that people have 3 years before it would escape to the state, and that we would be notifying the controller of any refunds that had not been claimed. Is that going on, and is to further protect the taxpayer? I don't think we'd lose any taxpayers, because the refunds are going to people that own real estate, and they would have a good address of record, I would assume. But I don't know. Do we have any quantifiable amount of money that is to the state because they're just not claiming it as a taxpayer? Anybody know, understand that? What happens if we send a refund check out to somebody and it's never cashed?
Well, Mr. Schaefer, to try and answer your question, sir, the money would, if a refund is not received by the intended recipient that we know of, or we don't have an address, the money will sit at the county level for a certain number of years. And then under the government code statutes, I forget, it may well be 3 years, I'm not sure, I don't remember now the exact period of time. It will be sent up to the state, where the state controller's office controls the state escheatment process. And the state controller has to use whatever information they have access to give notice to the recipient of that money that, hey, you're owed money and we're holding it. right? And if the state, after a certain period of time and notice, you don't come to the state and say, hey, Mr. or Ms. Controller, I'd like my money, please, then that is cheats to the state.
Yes, I would imagine that we have a good address or presumably good address on every refund because we're dealing with people that own real estate. Am I right in that presumption?
Well, you're often right, Mr. Schaefer, but I can tell you that it's not always that way, especially with businesses and partnerships. Businesses and partnerships in theory can last forever, but as we all know in real life, that's not always the case. For various reasons, a business or a partnership disappears.
I say,
And,
yes.
and especially with incorporated entities, to wrap up a corporation, of course, you're supposed to file certain information with the California Secretary of State's office, which provides a contact point for the now defunct corporation. That doesn't apply to partnerships. So you have partnerships of 2 or more individuals, real live human beings that held property as an ongoing partnership at some point. The partnership disappeared for any number of reasons. Now a refund is owed to that defunct partnership, but it doesn't exist anymore. What do? Who's, there's no way to easily track down the people, if they're still alive, who made up the partnership that is now defunct. And that's not just theoretical. That's real life. I can tell you, Los Angeles County is in litigation right now in a partnership situation where the partnership that brought the appeal and is due the refund went defunct. And there are subsequent.
Is a lot of money being involved, and we're not just
Uh,
talking about a couple $100?
It's business property, sir. It's a good chunk of change. Yes, sir.
Oh. Oh, thank you, and it's always nice to see you, as we do often.
Good to see you, sir. It's a pleasure to appear before this board and all the members. Thank you, sir.
Thank you. I think we have a question here from our Deputy Controller, and then I think the Vice Chair has one last question. Go ahead, Deputy.
I appreciate that, Mr. Vasquez. So I want to go and focus my question on topic 2, good cause. Prior testimony indicated AAB members often grant postponements almost universally due to uncertainty about good cause. So would providing a framework of what constitutes good cause and what does not constitute good cause improve consistency without imposing rigid bright line rules? And I'll open that up for all the panelists.
Like Ms. Moore wants to take it on first.
Absolutely. I think that anything where we can give our board members, especially those who are not attorneys, confidence in making a determination, that it will be helpful in, honestly, in allowing them to say no at times when it isn't a reason that is appropriate. I mean, as we all know, good cause is a legal term of art, and with as much training as many of these board members need when they come in, not all counties have the resources to provide that training, or they don't have county counsel in the hearing room with their boards during hearings to assist with those decisions. And so providing these guidelines would especially help those counties that don't have the resources for that. Attorneys, if they're going to participate in these boards, are taking time away from their billable hours. So it is more difficult to get, at least from our perspective, attorneys on assessment appeals boards. And so a lot of boards are made up of, other professionals. And this really is a legal determination. So this would assist tremendously in that.
Appreciate that. And if there's no other panelists, I have one other question in regards to topic 3, scheduling and exchange of information. Current law requires exchange to be within, I quote, reasonable time. Is that standard too vague to enforce meaningfully? And is there reform needed around what it actually means to be within reasonable time?
You want to take that, Ms. Moore?
I would just defer to the group. I don't think that we have a consensus from CCBSA on that topic right now.
I can't see hands of the other members, but I don't know, Ms. Taylor, are you able to see them better than I can? I don't know if anybody wanted to weigh in.
It looks like Mr. Parker would like to weigh in.
Okay.
Thank you. I would say a reasonable time, you know, as a lawyer myself, obviously, and somebody who has practiced law for this is my 40th year now as a licensed attorney. Reasonable is a really vague standard. And going back to Mr. Gaines's question, given that AABs operate as a quasi-judicial entity, admittedly administrative, but still quasi-judicial, I think there is inherently a degree of vagueness in what is going to be reasonable in any given appeal situation where a postponement or a continuance is asked for. And it's going to require discretionary judgment, hopefully informed judgment, but still nonetheless judgment and not an automatic rule or mathematical equation type of approach. So, and I've said this before and I apologize, but I think it bears in this particular instance, saying again, you're going to have to look at the circumstances of the particular appeal. For instance, how many times have continuances or postponements been granted in the past? Is there a really good reason given by the party seeking the continuance or the postponement? Hopefully it's not the dog ate my homework sort of basis. If you have parties, meaning the taxpayer and the assessor, in disagreement over what information needs to be exchanged between each of them, and you're not talking about a formal exchange under Rev and Tax Code 1606, that's going to hang up the preparation of both sides in getting ready for the appeal hearing. And those are just a few examples. It's necessary a subjective, factually informed decision making, and I don't know how you escape the nature of the subject in general, at least in my view.
Appreciate that, sir. And Mr. Vasquez, if I may, I like to go around to each panelist here because we're running short on time. Just a yes or no would be fine. Do repeated continuances in complex cases materially crowd out smaller taxpayer appeals? Yes or no? We'll start with you, Ms. Ann.
Yes.
Mr. Parker?
Yes.
Yes.
I think you're on mute, last panelist.
I'm sorry, and yes.
Okay, thank you.
Thank you. Looks like Vice Chair still has another question or two here. Go ahead, Vice Chair Gaines.
Yeah, it was suggested, I believe, by Leslie Park about just getting larger print for the instructions. And I mean, is that something that we would do through our form? We've got as a sample form we're working on here, but could it be formatted so the print was larger so it'd be easier to read for an applicant? And is this available online also? And could it have larger print online versus a paper copy?
Once again, David Young, Deputy Director, Property Tax Department. Thank you for that question. We prescribe the content and the format which it's in. We can actually put it in larger print, but you are correct. It is up to the assessors to actually put it online. when they format it, it may turn out a little bit differently. And if they print it out I'm sorry, not the assessors, the clerk of the boards, how they decide to print it out and how they decide to post it online. But we prescribe the actual format itself and the content, so we can control part of it, but ultimately there is some discretion on the at the clerk's side.
Okay, that's great. And then I just have a broader question in terms of, we have a working group here. Will there be a meeting of interested parties that will get into the nitty-gritty? Because there's a lot of great ideas and suggestions here, but I'm wondering, it seems to me that an interested party group could refine it and figure out what the priorities are. I mean, we're discussing these in a public hearing, but is that next? I'm just trying to figure out what is the process. Because I know we've got a working group here, and that's fantastic, but I don't want it all to just go into the atmosphere.
My hope is that after this, we're gonna go back through our notes and stuff, and hopefully there's areas where we see consensus. We'll bring it back and make
Okay.
recommendations to the board and invite participation from all the participants. We've had several folks, some that have left their positions but are still involved in some capacity, and we'd love to get their take and input on this, hopefully to help streamline this process.
Okay,
And in some cases, like on the refund thing, is an issue of, how do we expedite that?
okay. Does it go to an interested parties group of clerks and assessors
Yes.
that would then refine it
That's my hope.
or make changes or whatever? Okay, good. Let's try and
Oh, Chair.
understand
Lieber,
it.
go
Thank
ahead.
you.
Yeah, I want to make sure that we're raising reasonable expectations among the assessor community and the other stakeholders who are involved, that we do have to respect the processes that we have at the BOE, including our disability council and others. So I don't want to hold it out immediately that there's going to be an interested parties process until we take a look at what our normal process is. And here's our executive director.
Yvette Starr, Executive Director. I was under the impression that this work group was acting like interested parties, that the work group was providing their comments on what they wanted. And then your staff was going to put together a report and with suggestions that will be distributed to the entire board.
Yes.
And the board will make a decision on which one of these suggestions we want to direct the executive stars to implement.
No, maybe I wasn't clear.
Yeah.
After all this, we'll take it back, bring it to the board, and where there's consensus here, we'll bring it,
Then
we'll
you
put
bring
it
it
out.
to- yeah. Yeah.
I'm sorry, I don't know if that answers your question.
Would that assume that we would have buy-in by the Clerks Association and the
I will
California assessors?
assume that Member Vasquez's staff is going to continue to communicate with them and
Yes.
see
Okay.
if they are coming to an agreement. I mean, unless they want to come for another open meeting, but they're quite busy. But I'm assuming you guys will coordinate that.
Yes, we're hoping that, as we're putting it all together, especially areas that we think that might not have the full consensus of not only what we've discussed here, but of some of the other state partners that we've been working with, we'll run it by them before we share it with you folks, and
Yeah,
then
good.
see if there's a consensus here.
Excellent. Okay, that's great. Thank you.
Seeing no other questions from the group here. And I know we ran a little bit over on our little break, so I guess my question is to staff, do we want to take the lunch break now, or or do we move on? I want to be sensitive to our note takers here.
Yes, we
We
can
do it
take the
now?
lunch break now. We still want to go out to the AT&T operator?
Yes, let's go ahead and do that.
All
Let's
right.
close it out, and then we'll go ahead, we'll take our lunch break and then come back for the afternoon panels.
All right. We do not have any written comments, and we do not have any additional requests to speak on this item. Will, AT&T operator, can you please let us know if anyone is on the line that would like to make a public comment regarding this item?
Yes, thank you. If you would like to make a public comment, please press 1-0 at this time. 1 followed by 0. And nobody is queuing up.
And we have no other written comments, right? I know they handed out some things, but actually, most of those were actually delivered by the
Correct.
folks on the screen or in person.
That is correct. Those materials will be available on the board work group webpage on the BOE website.
Thank you. And with that, I'm looking at this, my clock here, it says 11:39, so we're going to give ourselves an hour. So, I'm sorry, Chair?
Yeah, and just a thank you to everyone who's participated in the first panel and to you and your staff for putting this together. It's very valuable input, and we definitely heard you loud and clear about things that you would like to see and things that you would not like to see. So thank you so much.
Yes, thank you all. And you're all welcome to stay on for the afternoon. We'll have other folks coming on, some in person and some again in Zoom, and we'll convene that. And as I'm looking at it, we have 11:39 here, so we'll regroup at 12:39. Thank you all. welcome back. We'll go ahead and get started. And it sounds like AT&T is all set to go. So welcome back. We are now going to be having our panel, excuse me, of the county assessors. And we have a number of speakers with us today, both in person and remotely. The first speaker of our second group panel is the newly elected assessor, Nasa Fligor from Santa Clara County. Congratulations on your recent election. And I believe she's on the screen somewhere. And I will, first of all, wanted to thank you and your office. You've been very active with our work group in the past with Larry Stone and a few other folks in your county, and really appreciate the input that we've been receiving, and especially the commentary that you've had as we started this process a little over a year ago. But with that, let me see if the assessor Fligor is online here. You want to begin with? I'm sorry.
It looks like Assessor Flagger's deputy may be on the screen. So perhaps,
Is it both? I don't know. I haven't met either.
oh, well, I saw her for a minute there.
Oh,
There she is, Nisa Flagger.
She might be muted, though. Hello, hello. I think I see one finger. Is that like 1 minute?
I think it's an unavoidable pause.
They might be having some technical issues over there. We'll give them a minute or two here. Oh, I see her on the screen now. Let's see if. I think you're still muted, though. We can see you. Just can't hear you.
Perhaps my team can check to see if someone accidentally muted everyone on Teams.
Who controls that? Do we control that? They should be able to do it, right? Yeah.
Can you hear me now, Mr. Vasquez?
Yes, now we can. Great. Success.
Thank you. And I apologize about that.
Not a problem.
Well,
Go ahead.
Thank you. And then thanks, Chair Lieber and other members of the Board of Equalization for allowing the Santa Clara County Assessor's Office to join you in this important discussion. We appreciate the opportunity to participate as part of this working group And as Mr. Vasquez mentioned, I was recently elected as the new Santa Clara County assessor, but I'm actually not new to the assessor community. I was the assistant assessor before, a member of the executive management team, and I was also the attorney for the assessor's office for a few years. And so I really appreciated listening into the earlier panel discussions that involved county council and hearing their perspectives. You know, our office is very much appreciative of these efforts, along with the other stakeholder groups, because together we really need to work together to identify ways to simplify, expedite, and create more efficiencies in the process. In Santa Clara County, we currently have 12,000 active appeals with a value in dispute of $155 billion, 98% of which are commercial. So figuring out how we can work together to improve this process is really a priority in our office. In fact, our office announced just this morning a couple initiatives related to the appeals process, including creating an internal task force to determine if there are operational changes we can make in the assessor's office to improve the process. We also extended the period for our informal review process. I know not all assessors' offices offer this, but Santa Clara County is one of the counties that offers this free informal process. And we're able to announce this morning that we're extending the time. Obviously, if there's a way for us to resolve these disputes and avoid the costly and time-consuming appeals, that's something that is a priority for us and something that we plan to work towards. But as has been mentioned since this morning, there are many stakeholders in this process, and to make real improvements, it will require collaboration among all of us. Our combined goal is to have a fair and efficient process that works for all the parties involved. And I, along with my assistant assessor who's here in our real property division, we will not repeat the suggestions and feedback that you heard this morning, but we do have additional suggestions that we want to share with the members of the Board of Equalization and the other stakeholders that are involved in this working group. With regards to the assessment appeal application, our office supports simplifying the form so that it will be easier for taxpayers to submit complete and valid applications, as this will help to expedite the process. So we support using plain language and less jargon, as others said this morning, especially in sections 4, 5, and 6. We also support, and I don't think this was suggested this morning, and I imagine there may be some counties that have this, but in addition to the instructions that we provide with the form, having an FAQ section, commonly asked questions that we receive from taxpayers on the application form, and provide additional information and direction there. So not only rely on the instructions that we include with the form, but having an FAQ page, because a lot of times our experience is it's the same questions we get over and over from different taxpayers trying to understand the form. We also would defer to the clerk of the board, but we do believe that we can ensure that the form has the bare minimum information necessary to move forward with scheduling the hearing, and delete the sections that are not necessary to schedule the hearings, since that's the primary purpose of that form. And I know there was a discussion earlier about the claim for refund section and whether or not we wanted to include additional information there. That is not something that we would support, only because we believe that the application form should be treated as an application form to have an appeal heard, and we want to make sure that's the focus of that form. Speaking of the refund question, in Santa Clara County, and I know every county is different, we actually have a good track record of turning around the refund. And my understanding is we do this on a rolling basis. So when a decision is made by the AAB, then that's actually put in the process so the refund can be generated. And we also have on top of that an internal audit process to ensure that we do not miss any refunds refunds that a taxpayer is entitled to. Two more suggestions on the appeals form. With regards to section 6I, we think it would be helpful to have a fillable field that the taxpayer can fill in instead of having them attach a separate sheet. And we can set a maximum number of words, but right now it's a very limited space, and we say if they want to provide more information, then they can attach a sheet. We think there would be an increased adoption and it would be simpler for taxpayers if they're able in a narrative form to just explain the basis of their appeal in that actual form. And then our last suggestion would be to include contact information on the form for the taxpayer to get their answers promptly. Our experience is taxpayers call the assessor's office frequently, asking about the application process, the application form. And obviously we're not the office that should be answering those questions. And so what we hear from taxpayers is that they're not able to get the answers, or they're not able to reach the department that should be providing that information. And so we believe having contact information on the form, a phone number that someone answers or gets back to the taxpayer within 24 hours, or an email address that gets a response within 24 hours would actually also help to expedite that process. The second issue I think the board is considering today is whether or not we define what good cause means for postponement determination. And as I mentioned, I was the attorney for the assessor's office. I was part of county council. And so I'm very familiar with good cause. And I think Mr. Parker mentioned, it is a legal term, but by us defining what good cause means, I believe it will be very helpful to the AAB members in making the determination on whether to grant a postponement. And so we support providing the factors for considering good cause. It will provide consistency, reduce arbitrary decisions, and number 9 in the proposed language, I think someone mentioned that we should not make this mandatory. It should act more as a guide. I think what's helpful about the language that's being proposed and how we define good cause is number 9 in that proposed language, because that's a catch-all, right? So we have 8 specific factors, and then we have 9, which does give an AAB member some discretion where, if there are circumstances or facts that are not listed above, then they still would have the ability to grant the request for postponement. We would also recommend that we have our AAB board members state the reason for granting the postponement, because our experience is when they're required to do that, they're not just saying, yes, you can have an extension, but they're actually required to state the good cause they're relying on, or the other facts and circumstances that are the basis for their determination. That would help to make sure that the decisions are more consistent and less arbitrary. And then I appreciated the example earlier this morning about avoiding the excuses of the dog ate my homework. And so, to the extent we can have taxpayers sign under penalty of perjury, or, some form that will really make sure that, whatever they provide for asking for a postponement, it falls within the good cause factors that we have. And then lastly, with regards to working closely with the assessor's office on scheduling hearings, I appreciated hearing from the clerk of the board and the other stakeholders, and the concern around ensuring that the assessor's office isn't unfairly or unintentionally being receiving preferential treatment, or there's any prejudice there. I do think, though, when we step back and we look at the process, I think we all are in agreement that we need to figure out a better way to schedule these hearings so that we don't run too close to the statute of limitation, which is only 2 years. And so if this is not the solution, our office believes that we still need to continue working together to ensure that the scheduling of hearings move much faster than they are currently. So for example, in Santa Clara County, and similar to other counties, the period is from July 2nd through September 15th. Most times, we may not receive a valid application that's been reviewed by the clerk of the board until, January of the following year. And then we have to do our own internal review. And so by the time a lot of these matters get scheduled, we're already into year 1 of the statute of limitation period of time. And so we would appreciate hearing other suggestions. If the assessor's office suggestion of having us propose dates for these hearings, and then the clerk of the board can always say that date doesn't work for whatever reason for the other factors they consider, that's understandable. But the assessor's office, by proposing a hearing date, at least it gets a date on the calendar that all parties would work towards. And if there are other reasons why the clerk of the board believes that another date works better for the other parties involved, that's obviously something that the clerk of the board would have the opportunity to adjust. Currently we have limited resources, as I heard from other offices, and we have many priorities in our office. So it's the same resources working on the same priorities. And sometimes we have the same appraiser with 150 matters that one appraiser would need to handle in addition to his or her production role. And so we really need to figure out a better way to work on scheduling hearings so it does not unfairly impact the assessor staff, while still recognizing that there are other parties that are part of this process that need to be considered. The last point I'll make on scheduling, and it's similar to a point that was made earlier about exchanging information within a reasonable amount of time. Reasonable amount of time, and I think this was Mr. Parker as well, as a very vague term. And I think what may help with the scheduling process, I'm going to step back and make a suggestion, whether it's with scheduling the hearing, providing information, moving the process along. I think what may actually help is having a certain number of days in which things need to happen. Right. And so understanding you have a 2-year calendar, the clerk of the board would need to set a hearing by a certain date. It gets sent over to the assessor's office. We would also have the same obligation to make sure oral review is done within a certain number of time. If the taxpayer needs to provide information, then the taxpayer also would need to provide that within a certain number of days, as opposed to having vague terms such as a reasonable amount of time. And so we think, if we're not able to be at the table where we propose dates for the hearing, then maybe another solution is for us to figure out a schedule or a timeline where a certain number of days are given to each party involved to get certain things done. And we actually have suggestions for that, but I will stop here and look to my assistant assessor and chief to see if they have any other suggestions on these 3 items. And that's it, Mr. Vasquez. Thank you again for including us in this discussion.
Thank you. Thank you for your recommendations and comments. With that, let me move on to our second speaker. And I just was told that the Honorable Jordan Marks is tied up, but we have his assistant here, excuse me, who is going to be joining them anyways, Mr. Martin Arias. So I'll let you go ahead and give your remarks. And first of all, thank you and your office, especially Jordan. He's been real helpful over the last year with this working group when we first started. So let me turn it back over to you. Thank you. You're welcome.
There we go. Thank you very much, Member Vasquez. Good afternoon, honorable members of the Board of Equalization. My name is Martin Arias, and I am the San Diego County Assessor Taxpayer Advocate. And I'm here on behalf of the San Diego County Assessor Jordan Marks' office. I want to begin by thanking Member Vasquez for convening this important work group and for fostering collaborative effort to improve our assessment appeals process. I also want to recognize my assessor colleagues, led by California Assessors Association President Kristen DePaul, along with our clerk of the board counterparts and the CADA leadership. Together, we are committed to delivering the highest level of service to our taxpayers and strengthening the integrity of our system. In advance of today's meeting, Assessor Marks convened a stakeholder session in San Diego County with our team of property tax and appeals experts, my taxpayer advocate team, Clerk of the Board Andrew Potter and Chief Deputy Ann Moore, and members of our community paid advocates. I'm honored to bring forward the collective opinions, recommendations, and reflections of San Diego County's entire appeals ecosystem. The message from our meeting was clear. We must invest in a better assessment appeal process. In 2024 alone, appeals filed in San Diego County put over $34 billion in assessed value at issue, representing approximately $340 million in potential revenue. The scale of what is at stake demands a system that is professional, modern, accessible, and fair. First, we must invest in our assessment appeal board members. We compensate professional superior court judges in our court system at salaries exceeding $160,000 annually to adjudicate complex matters. Yet depending on the county, assessment appeal board members may receive compensation as low as $100 per day. If we expect expertise, consistency, and sound judgment in highly technical property tax matters, we must professionalize these boards with compensation that reflects those expectations. At present, both the qualifications required to serve at the level of education and training provided of our assessment appeal board members fall short of what the public trust requires. Strengthening these standards is essential. Second, we must invest in technology that supports assessor, auditor, controller, treasurer, tax collector, and clerk of the board systems. Modernizing appeal infrastructure may not be glamorous, but it is critical. Bringing our systems into the 21st century will reduce delays, improve record retention, streamline administrative tasks, and create more operational efficient process. One that balances taxpayer rights with a timely adjudication. Many appeals stem from property tax bills that are not easily accessible, or in some cases, not archived beyond 5 years. The technology exists to preserve and provide access to these records. What we lack are the dedicated resources to implement these technologies. E-signatures should be standard statewide. Remote hearings should be funded and normalized so taxpayers are not forced to take a full day off of work simply to wait for their case to be called. We have restructured our approach to appeals in San Diego to ensure we are providing as much calendar availability to our clerk of the board to maximize the time necessary for adequate appeals calendar. These improvements would allow for better scheduling, greater coordination amongst parties, and more efficient use of public resources. Third, we must invest in making the process more accessible to the public. The assessment appeals board application is not user-friendly for the average taxpayer. The information sheets are dense, printed in small text, and difficult to navigate. Instructions should be written in plain language and integrated directly into the application itself. We also recommend moving the claim for refund checkbox, if possible. Every application should automatically be treated as a claim for refund. If a checkbox is legally required, it should be structured as an opt-out rather than an opt-in. That approach would be far more intuitive for taxpayers. Additionally, the filing window is extremely narrow. During that constraint timeline, many applicants struggle to provide the correct information, which can result in rejection of their appeals application. To ensure fairness, taxpayers should be allowed to amend their applications, particularly Section 5, to correct deficiencies and perfect their filing. We should not extinguish substantive rights based on technical errors that can be remedied. Finally, with respect to what constitutes good cause, we recommend explicitly including consideration of whether data has been exchanged pursuant to Sections 408 and 441D, and whether both parties have had reasonable time to review that information. In San Diego County, we are implementing safe safeguards to ensure taxpayers have adequate time to review our records and that our team has sufficient time to review theirs. A fair process depends on meaningful access to information for both sides. Thank you again, Member Vasquez and honorable members of the board, for convening this important forum and working group. We appreciate the opportunity to strengthen a system that serves not only government, but every taxpayer who depends on a fair and transparent appeals process. Thank you.
Thank you. With that, we'll move into our third speaker, which is the Honorable Kristen DePaul, who's here with us. Also the president of the California Assessors Association, CAA, from Modoc County. Welcome, and thank you for your participation in the past as well, and your and the association's support.
Good afternoon, Chair Lieber, honorable members of the board, members of the public and staff. Thank you for the opportunity to speak this afternoon and offer perspective from the California Assessors Association and small county assessors. My name is Kristen DePaul, and I am the assessor recorder for Modoc County, and I am also serving as the president of the California Assessors Association this year. The CAA represents elected and appointed county assessors who are constitutionally charged with fairly, uniformly, and lawfully administering California's property tax system. The association promotes professionalism, consistency, and public trust through collaboration, education, and compliance with state law and BOE guidance. Today's discussion on the assessment appeals process is a topic of great importance to the association. The assessment appeals process is one of the cornerstones of the property tax system. It ensures taxpayers have meaningful access to due process, provides transparency and accountability and valuation, and reinforces public trust in the work of county assessors. When the appeals process functions well, it affirms that assessments are not only accurate, but equitable, and that disagreements can be resolved through an orderly, impartial, and accessible process. Today, we want to underscore the importance of preserving the integrity, efficiency, and clarity of assessment appeals, as they are essential to maintaining confidence in local assessment practices and overall stability of California's revenue framework. Obviously, small counties don't experience the volume of appeals that large counties do, which makes our caseloads much more manageable. However, confusion over the appeals form seems to be a statewide issue. We have a lot of constituents who will actually stop by our office to get clarity on differences between supplemental or regular assessments, or whether they're appealing a rule change or escape or et cetera, which box to check on anything, really. This is obviously more of an issue if they are unrepresented, but a layperson just doesn't understand the tax code and verbiage. Despite the thorough explanations and the instructions, we find that taxpayers still find them confusing or just completely ignore them. However, there is a balance to strike between simplifying the form for the taxpayers and preserving the utility of the form for the assessors and the clerks of the board. There may be benefit in some modest formatting changes, such as leaving writing space where narrative explanations are required, or optional prompts that encourage taxpayers to clearly state the specific issue in dispute. Even small improvements can improve the quality of the information submitted and enhance taxpayer understanding and confidence in the assessment appeals process. Most small counties don't have the same issues with continuances and postponements due to our more limited number of appeals. However, I do believe that providing guidance on appropriate factors for consideration for allowing continuances or appeals would promote greater consistency across the counties while preserving some local discretion. Many of the smaller county board of supervisors also sit as their assessment appeals boards. Clear guidelines would stream the appeals process, but also provide clarity to appeals boards that lack any kind of legal background, avoiding delays or additional hearings just to resolve whether the burden has been met to justify continuance or postponement. Ultimately, this kind of guidance strengthens transparency, expectation, due process, and confidence in the assessment appeals system, while also reducing administrative strain. Small counties don't normally experience the same struggles scheduling hearings due to our limited number of appeals, but adopting some best practices can be beneficial for clarity and uniformity. Early and regular communication about anticipated appeal volumes, staffing capacity, and board availability can help avoid conflicts and improve efficiency. Pre-season planning discussions before hearing calendars are finalized and clear protocols for communicating scheduled changes to all parties might be helpful. Even modest improvements can improve coordination and efficiency, conserving staff resources and improving the experience at the county and taxpayer level.
Thank you. With that, we'll move into our fourth speaker, which is the Honorable Jeffrey Prang, Los Angeles County Assessor's Office. And I understand it looks like we have 3 individuals from there. Is it Lawrence? I have Lawrence Liu here, Chief Appraiser Lisette Cornejo, and the Principal Appraiser Gregory Lejon. Are they on?
They're on Teams.
Member Vasquez, actually, Chief Lizette was tied up
Oh.
in another matter, and so her principal appraiser, Greg, is here to follow up. But first off, I just wanted to say good afternoon to everyone, Chair Lieber, Member Vasquez, members of the board. Thank you for inviting us on this opportunity to appear today. As you guys all probably know, my name is Lawrence Slew. I'm Special Assistant to Jeff Prang. And with me, I've already introduced him, but it's Greg Leung. He's our principal appraiser with the Assessment Appeals Unit. And, we're here just to offer any additional feedback and to answer any questions related to the work group discussion topics. Greg, did you have anything to add?
Yes, if I may add something. Good afternoon, honorable members of the board. Thank you for the opportunity to provide input on these matters. My name is Gregory Leung. I'm the principal appraiser with Los Angeles County Office of the Assessor. I would like to speak on the third item of discussion on the development of additional guidance on assessment appeal scheduling coordination. As I work in our assessment services section, one of my functions is the coordination and scheduling of our staff to represent the assessor at Assessment Appeals Board hearings. In my experience, I feel that we have developed a pretty good working relationship with the clerk of the board, and we already communicate frequently with the shared goal of efficient scheduling. Looking at the proposed language for the additional guidance, it would require the assessors to facilitate the scheduling process by categorizing applications into several categories. In Los Angeles, a process already exists that allows the clerk of the board to know how to categorize some of these applications. For example, properties in Los Angeles are assigned to various regions or clusters based on factors such as location and property type. Properties in residential regions and single-family clusters may generally fall under the straightforward case category, and properties in our major real properties division regions generally would fall under the more complex category. In addition to this classification, I additionally communicate with the clerk of the board fairly regularly if I'm aware of any applications that we have that are likely to be easily resolved through acceptable recommendations from the assessor, or if there are applications that I know will be moving forward with complex issues. This helps the clerk of the board identify which applications to schedule together and how many applications to schedule to minimize some of the board downtime. And in return, the clerk of the board communicates with me anytime there may be sudden changes in board assignments so that I can ensure that we have adequate coverage on all of the boards. So we feel that the existing guidance from LTA number 2013-39 already provides sufficient direction, and county assessors may already have good working relationships with the clerk of the boards, just like we have in Los Angeles County. Therefore, the development of additional guidance on scheduling coordination may be unnecessary. Thank you.
With that, was there anything else, Lawrence Liu? I know you were missing Lisette. I'm assuming he covered everything she was going to talk about.
I think so, and we're going to be answering any questions that the board may have as it relates to some of the other topics. But I thought our focus was more on the scheduling point.
Thank you. With that, let's move on to our last but not least, the fifth speaker here, which is the Honorable Matthew Maynard, who's in person here, the chair of CAA Subcommittee on Standards from Placer County Assessor. And I understand you also have an assistant with you, Brian. Is it Wirtz? I don't know if I'm pronouncing your last name.
Yes, it's Wirtz. Thank you.
Okay.
Yes.
And with that, I'll turn it over to you.
Thank you very much. Good afternoon, Madam Chair, members of the board. To introduce myself for the record, I am Matt Maynard, the Placer County Assessor. While I am the current chair of the Standards Committee of the CAA, what my team and I will discuss today is just from the perspective of Placer County and does not represent the CAA. I would just like everyone to be aware of that, as we just heard from the CAA president, and I would not entertain the idea of stepping on what she just said. I would like to thank the board for letting us be a part of this discussion. We truly appreciate the board examining this topic and creating the opportunity for open dialogue and collaboration. Placer County, as a medium-sized county, can only speak to our experiences with assessment appeals. While we have had our own challenges and accomplishments in this area, it is difficult for us to truly understand the pain points that accompany the massive volume of appeals that large counties must address, or the challenges that many of the smaller counties face when assessment appeals occur so infrequently that formal processes and procedures may not be well understood or even deemed necessary in some circumstances. One of the best decisions that we've made for our office is forming a specialized assessment appeals team. This team is tasked with managing all appeal matters within our office, and this organizational structure ensures consistency in addressing and resolving appeals, and it enables effective coordination with our clerk of the board on administrative issues related to assessment appeals. Joining us today from my office is Assessment Manager Brian Wirtz. Mr. Wirtz brings with him over 20 years of experience in handling assessment appeals within our county. And before taking charge of our assessment appeals team in 2020, Mr. Wirtz served for 17 years in our county counsel's office. So his extensive experience with assessment appeals from various perspectives provides him with a valuable insight that has greatly benefited our team. And with that, I would turn it over for Brian to go into a little bit more in depth.
Thank you, Matt. Good afternoon, board members. Like Matt said, and for the record, my name is Brian Wirtz. I'm an assessment manager with Placer County. The comments I'm going to make today are primarily from a perspective of folks who are in the process of working on the appeals from the assessor's office and talking to the applicants on a daily basis. And so it's kind of more of a boots on the ground look at things. In Placer County, historically, half of our appeals every year are residential appeals. The other half are business property, and ownership. And so as a result, we do a lot of talking to individual taxpayers, homeowners. And the thing that we have gathered over time is that I don't think, and I'm talking to the assessment appeals, the form itself, I don't think the confusion has to do with the form. The fact is that assessment practices in California is not a simple process. It's rather complex, rather confusing, and it only gets more so every year. That is the starting point for a homeowner who has, they think the assessor's office has got their value wrong and they want to appeal it, but they don't know how. There's quite a bit of conversation that goes on at our clerk of the board's office with applicants. And even after that occurs, and even after an appeal is filed, oftentimes when one of my team starts talking to the applicant, what their true beef is not necessarily what ended up on the form. And so in echoing Honorable DePaul's comments, I think adding additional space in the other section would be incredibly helpful. There have been several times in the last year where we've looked at an application and it got filed as a Prop 8 appeal, which was certainly legally permissible at the time. But when you start reading the comments and talk to them, they're really not challenging the Prop 8 value. They're actually challenging new construction, or they want to file a prospective-based year. They just don't know the terms. And so in those particular cases, we will acknowledge that, we'll recognize that, and then we suggest that they contact the clerk of the board for possible amendments to their application. That seems to be quite helpful, with the goal of getting the applicant, to a point where they can challenge what their true complaint is. It's good customer service. It's, it helps the process. I think I'll go to the good cause factors at this point. We don't have anything additional to add. We would echo many of the comments that were made today. We have in the past had some issues with repetitive postponements and continuances. And if you have 12 appeal slots tied up on one appraisal unit and it gets appealed twice, all of a sudden there's 36 appeal slots that have been taken up by somebody kicking the can down the road that, and so other taxpayers and other applicants are not afforded a speedy appeal at that point in time. Most of my comments are going to be talking about the cooperation between the assessors and the clerk of the board. I think in Placer County we have a very good working relationship. A number of years ago, we had some difficulties, and in doing some research, LTA 2013-039, which your board has in its agenda package, it's been mentioned, we found it and we took it to heart. And we came up with an internal process by which, I'll explain it briefly, and it works very well for us. It may not work for other counties. We have one appeals board. At their administrative meeting in July, they set the following calendar year, the hearing schedule for the following calendar year. And so at that point, the hearing dates are known at least 6 months in advance. In addition, the board schedules several tentative two-day hearing dates. They're kind of penciled in for those appeals that could take a lot of time and be very involved in. And so we have those, and we can request that those have a hearing. Applicants can also do that. With those hearing dates known, the assessor then determines the proposed hearing schedule. So we look at all the appeals, we look at the two-year period, we see which ones are the most stale. We will then send recommended appeals. We set a recommended calendar. We send that to the clerk of the board at least 90 days before that particular hearing. The clerk then has plenty of time to look it over, to review, to see if there's any issues with it, make suggestions, make changes. And then if there are none, the clerk will then send out the notices, with at least 45 days as required. This has worked very well. There's some advantages to this. Since the assessor staff knows what's being recommended, the number of times that the assessor's office has had to postpone or continue a hearing, in the last 6 years, there have been 2 or 3, to my recollection, times that we've continued or postponed a hearing, and that's it. And those were all 3 due to the last-second staff illnesses. So one of the parties isn't going to be kicking the can down the road. Now, I can pretty much say with certainty that if we did not have that ability, we would be doing as many continuances as applicants. Now, we also understand, though, that applicants aren't just dealing with Placer County, they're dealing with every other county in the state, potentially. Oftentimes, there are hearings, AAB hearings, on the same day in multiple counties, and we get that they need to continue, and we're willing to work with applicants on any continuances because of that. Another advantage to the process is once the assessor staff makes the recommendations, my team can start contacting applicants and discussing their appeals with them early on. Oftentimes, we're able to get things resolved well in advance of the hearing. So I would recommend that if your board contemplates any sort of formal guidance or new property tax rule related to scheduling, that I also would recommend that you add language that would caution the use of any sort of process like this to not be used by the assessor to gain any sort of a tactical advantage or anything. The key to all this is absolute integrity and an understanding that only scheduling should be discussed in these types of conversations and not the merits of the particular appeals. There cannot be any sort of even a semblance of impropriety in order to protect this process. And with that, I will be happy to answer any questions.
Thank you. Excuse me. And thank you for all your comments from all the different speakers on this particular topic. I wanted to raise a couple quick questions, and I'll turn it over to my members on the board as well for comments they might have. Similar to what I asked the first panel on the refund, and some of you kind of touched on it, is the question of whether the BOE can add refund information to the appeal application form. In your county, I should say, in your county, does the assessor typically have the most up-to-date information on taxpayers? And do you believe there's a way for the BOE to encourage information sharing with the offices that process these refunds? And I'll start with, I guess, our panel here that's on live. The president's going to take it on.
In my county, I can speak only for MODOC and small counties in general, the refunding process isn't really stuck in our office. We process our refunds pretty quickly. I know that we've had discussions with CADA and with Ryan LLC and et cetera about these issues. And I do know that there are counties that are struggling with that. And a lot of times, sounds like one county specifically, it's a systems issue. It does a lot of times fall on our auditor counterparts. And a piece of that is because they hold their refunds during the roll close process, and they are waiting to import all of the data, do some of the changes before they start issuing refunds. Some of our county refunds will do immediately, and it'll be 9 months before the taxpayer sees a refund. And it's significant. We get phone calls all the time. It is as much of a burden to our offices as it is to others, because we're constantly dealing with taxpayers that are frustrated because we've promised them a refund. We've sent the paperwork to them showing that they're going to get a refund, and they're not seeing anything, and they're waiting on that money. I don't know what kind of dialogue you guys could have with the Auditors Association. I do think they're aware of this. It sounds like it's been an issue for the last couple of years. We've reached out. We've tried to encourage better participation in ways that they can issue refunds even when they are in the process of pulling in, our roles and doing that transition. And I'm not sure if there have been improvements. Our county, we actually started a tri-county or a tri-department panel, our tax collector, assessor, and auditor. We meet quarterly, and this was our first topic. And our auditor did say, I will try, I'll set a quarterly schedule, and I'll start scheduling them. I can do it during these time periods. It's just difficult on my office, but I will be more proactive about it because it causes the tax collector. People are confused about who issues the refund. It causes the tax collector unnecessary phone calls as well. It's just hard when you're dealing with different department heads. Anybody else want to?
I also want to echo your remarks. I'll tell you, in San Diego County, we also have a quarterly meeting where we interact with the auditor and controller and the treasurer tax collector, essentially to bring up systemic issues and things of that nature. Now, in San Diego specifically, we just had our auditor and controller and our treasurer tax collector migrate to a new system where we saw, returns were typically taking 6 to 8 weeks, are now taking about 20 weeks to issue. And, I got to tell you, that's an issue on multiple levels, right? Because we're having to pay taxpayers back with interest, which is our tax dollars that we could be using for other great services. And so I agree. I don't think that it's a issue of us communicating and engaging with our counterparts. I think it's a system issue, and we need to try to address that directly at the core there.
Thank you. Any comments from LA or Santa Clara? I see it looks like Lou wants to chime in.
Yeah, for Los Angeles, we share a similar sentiment with San Diego. Technology, the assessor's office, we recently, as Assessor Prang has stated multiple times, updated our assessor's platform. So we're running on a cloud-based technology, but our other tax counterparts, they have not upgraded their technology yet. And so typically during roll closure, our auditor has to shut down their system so that they can't receive information from us. So that sometimes does delay refunds during their period where they go dark. And then on other instances where we see that there may be a refund issue is it has to do with any sort of refunds that are issued beyond the 4-year statute of limitations. So typically the auditor's system in LA requires that the assessor office do some sort of manual processing to sort of manually feed the information into their system for it to get processed. So there are times where, after an appeals case is resolved and a notice of board action is generated and we've provided that to the auditor, sometimes they don't go through. And it's not because of the auditor's fault or the assessor's fault. It just kind of gets log jammed in between the two systems. So then the assessor's office in LA County, we would have to do a manual processing procedure to sort of force the information through into the auditor system. And that sometimes can cause delays. So, you know, refunds is always a big issue, but our offices are always trying to respond to them as quickly as we can. But, you know, with technology and the differences in technology, that sometimes poses a problem. Greg, did I get everything, or is there anything else that?
Nothing else to add.
Yeah. Thank you.
Thank you. Any comments from Santa Clara, or we move on?
We can move on, Member Vasquez. I think everything has been covered by my colleagues.
Thank you. With that, let me look at my colleagues. I think we have our chair wants to have some questions, and it looks like the vice chair as well.
Thank you. I don't have any questions. I'm struck by how similar our panels have been in terms of the concerns about people trying to understand and make their way along with these initial steps in the process. And I appreciate having the diversity of small, medium, and large counties represented here. And I'd really encourage folks to submit written comments too, as well, before we have our next meeting scheduled. And I think that would be very valuable. I've got a whole notebook full of notes now, but anything that you submit to us in writing, we will use. Thank you.
Thank you. Vice Chair?
Yeah, great. Great input. Thank you very much, the panel. I was just, I like this idea that was suggested by Assessor Flygor. Am I pronouncing it right? Okay, Flygor, okay. But a lot of great ideas here, but this contact phone and email seems like something that would be fairly simple to add on to the assessment appeal application in the event that there are questions. Also, like the comment about a good cause definition. And I'm just curious as to whether, you know, is there a legal issue there? By defining it, do you then invite potentially more litigation, or because, you know, it can be in the eye of the beholder in terms of good cause. At least I'm just speculating, but.
Right, and then because, thanks for that question, Member Gaines, it's because it would be defined and it's a quasi judicial body, it would be within their authority to make that determination about what's good cause, especially if we spell out what the 8 factors are, and then still have that 9th factor, which gives them a little bit more flexibility in making the determination.
And should that be determined on a per county basis, or would there be a rationale for a statewide good cause definition? I don't know. I'm just asking.
I think for uniformity, or recommendation would be to have it done statewide, where we adopt certain factors that would define good cause.
Okay, very good. And that's Assessor DePaul, is that something the association's talking about, a statewide definition for good cause?
No.
Okay, I saw you shaking your head, so I was curious.
No, I do agree with Assessor Flygor that
Yes.
we are really focused on uniformity in the assessor's offices. It's easier for all of our constituents if they know what to expect, whatever county they're walking into. And so we would welcome guidance handed down at the BOE level that would give us and our assessment appeal board any kind of training. Like I said, for small counties, our Board of Equalization our Board of Supervisors sits as our assessment appeals board, and it is brand new for them every time we meet. So we have so few appeals that it's really out of their regular realm of duties. And so any kind of guidance that you can issue really does help boards that don't have that kind of training. And so any kind of uniformity helps all of us, honestly. It helps them know what to expect and helps the taxpayers understand what to expect as well.
Sure, okay, that's great, thank you. And then Assessor Maynard and also Mr. Wirtz, you had made a comment in reference to repetitive appeals. And so how do you make that determination as to what is legitimate? And an appeal that keeps surfacing?
That is going to be fact-specific. Just from some of the hearings I've been in, we had an agent request a second continuance, and when the board asked why, he said he had to go to a golf tourney. And so the board asked if he was participating in the tourney. He's like, no, I'm just going to go watch. That was one where our board said, no, we're not going to, properly, our board did not grant that one. However, I think there is some confusion as to what is and what is not good cause, and our board historically has erred on the side of granting the continuance under the theory that taxpayers should get their day in court, and any question should be resolved in the taxpayers' favor. That does, like I pointed out in that example, cause some scheduling issues. We have 12 hearings a year that have been calendared, and historically around 500 to 600 appeals a year. I can't even imagine 15,000 or however many LA had, but it's another matter. So we have a certain number of appeals we have to hear every year, and so when we have repetitive continuance, it does take away from other people's opportunity to get theirs resolved timely.
Great.
So guidance, that's a very long-winded way of saying guidance would be helpful.
Okay, how about these automatic appeals?
I'm sorry?
Automatic appeals that come up, you mentioned repetitive, but there are some entities that just automatically appeal every year,
Protective.
right?
Yeah,
So
we
how do
protect the
you-
filings.
Yes.
How do you discern whether it's, because that takes a lot of time, right? You want to preserve the rights of the taxpayer, but you're also spending a lot of taxpayer money for items for an issue that may not be legitimate. So I don't know, Mr. Arias, if you'd like to comment, or
Sure.
Assessor Maynard, anybody, please.
Yeah, so, in San Diego County, we've started partaking in the informal appeal process, which allows, once somebody opens up the protective appeal, it allows for us internally to start to review and digest some of the information prior to actually going to the appeal meeting. And so, through that, we're able to ask for, comps and different things from the taxpayer. And we're able to digest that together with them in an informal way, right? And I think that's the purpose of the protective appeal, is that if we're not able to reach an agreement informally, they still preserve their right. And we found that that's the best way we've been able to work with taxpayers to discern on, the repeat, just blanket filers versus the legitimate filers. And so I think that's San Diego's take on it. We're also a larger entity. We receive way too many appeals. So we're in a good spot there with the informal appeal process.
Great. Anybody else like to comment?
Yeah, Chair Gaines, sorry. Yeah, so Chair Gaines, on behalf of Los Angeles, I think two things that we did helped eliminate a lot of these repetitive applications. One, Assessor Prang is very good at sharing information that if taxpayers have any questions regarding their valuation, their base year value, if they have a decline in value question, that they can always come and reach out to our office. We would be happy to sit down with them to kind of review their cases. I mean, so we definitely try to nip it at the bud if we can early on. I think also our clerk of the board actually has a filing fee for applications, and that actually has reduced a lot of protective filing. So tax agents are generally aware that they're not going to just file for protective filing's sake. They want to make sure they have merit in their case before they file. So those are two items that I know that has helped reduce this situation that you're mentioning.
Okay, and is that on commercial side or residential? Because I think of someone who can't maybe afford a fee.
Right.
How do you deal with that?
That's for all types of applications. I mean, generally, the more sophisticated the applicant, if it's like a commercial property, they usually have legal representation that already reaches out to our office, and they probably have us on speed dial. But in terms of the fees, I'm not too sure how the Assessment Appeals Board works out their fee structure, whether there is, they take into consideration, people that have low income or whatnot. Because our filing fee in LA County is actually quite low, and it's a uniform, I think it's like a $50 fee regardless of the property type.
Very good.
And, you know, one of the things that came up, I mentioned that we had kind of like a stakeholder roundtable on Monday with some of our entire appeal ecosystem. And one of the things that came up there is along the lines of a filing fee is for repeat filers. So you're gonna have the agents and the folks who are filing 100 appeal applications or what have you, right? And so once you reach a certain threshold, is something that we're exploring. But I'm gonna say that we're working together with our partners to find out what that number looks like. And to, because I truly believe that there is a certain number there that discerns whether you're just doing it to do it or they're legitimate claims. And so working together with our partners to come up with that, and then also identify what the correct dollar amount is, right? You're absolutely right. We don't want to prohibit or inhibit any of the residential taxpayers who are maybe low income, and this is a make or break, right? We also don't want to be taxing people out of their homes, and so we want to make sure that we're doing it in a fair, equitable way for our communities.
Yeah, good. Great. Thank you.
I believe that Assessor Flygar's hands up.
Oh, was there another question, another comment out there from, who do we have?
Hi, Chair Gaines. It's
Oh.
Assessor Flagger, Santa Clara County. Just wanted to add to what has already been said and share what we do in Santa Clara County with those repeat filers. Three things we do here in Santa Clara County. One, we're also one of the counties that has the free informal review process, which we take advantage of. And to San Diego's point, we're able to resolve a lot of matters through that informal review process. We're also very proactive when we get an appeal application where we can reach out to the applicant, and sometimes we're able to proactively talk through what the issue is and also get that resolved. So even if they don't initiate the request for an informal review, sometimes just by reaching out to clarify information on their form, we end up resolving it because the parties have a better understanding of what the issue is, and it's something we can resolve. And the third thing we do here in Santa Clara County is we proactively review 345,000 residential cases every year. And so we're able to do this before June 30th, make any adjustments we need to make before we have to send out the NAV card at the end of the year. June 30th. And so all those steps that we take here in Santa Clara County definitely help to address those repeat filers and to minimize the impact on our staff here. And I will tell you that these applicants and even their agents are very appreciative when we do this proactively and we actually try to resolve it. Because as Lawrence said, the legitimate ones, the goal really is to resolve the matter and avoid the costly appeal. And so they're willing and happy to come to the table with us to see if we can resolve it before September 15th.
Oh, that's great. Thank you, Assessor Flagger.
With that, I believe our Deputy Controller had a couple questions.
Thank you. I really appreciate this conversation. Has been very, very insightful. In regards to topic 3, scheduling coordination, we've had conversations over the past year requesting stronger authority to coordinate with clerks while avoiding prejudicial patterns. So what safeguards would you all ensure in regards to coordination that does not appear to advantage the assessor and your office?
Yes, in answer to your question, like I alluded to during my primary comments, we limit our discussions to simply scheduling matters. We do not talk about the merits of the appeal. We don't even get into what kind of property type it is. We just.
But do you like stop the conversation right there, or do you have a third party or
No,
like a lawyer on the call?
We just stop it. Both parties know that is it. That's all we can talk about is, we have the following 53 appeals that we're recommending for this hearing date, and the clerk says, well, this one looks like it's a Prop 8 appeal, but there's a base year appeal that was also filed, and we look and said, oh, yep, you're right, we should have the base year appeal first, so we have something to bounce the Prop 8 off of. So can we switch those? Fine, done. That's essentially the limit of the discussion.
It's good to know, good to know. So in regards to topic 2, good cause, should failure to timely exchange information be weighted against a good cause finding?
I would be in favor of that. Oftentimes, we'll send out requests for information letters and hear nothing. Well, and then we'll follow up with another letter asking for the information and hear nothing. And, you know, a week or two before the hearing, all of a sudden they pop up and decide to send us a whole bunch of information. And by that point, the appraisal's already been done. We've already found the comps. We've already got the value worked up, and we're working on a presentation. That's a point where, you know, it causes frustration. I get it. Tax agents are very busy. You know, sometimes many of them are overworked. They have multiple counties to deal with. I get it, but it does cause some problems, and I think that might not be a bad idea to take into account.
It's good to know. And then my very last question, you've all also raised the need for applicants to provide a clearer opinion of value at filing. So would a required stated opinion of value materially accelerate the exchange of information?
Frankly, from my experience, we don't give much credence to the applicant's opinion of value that is on the AAB application, particularly if they come from tax agents. Typically, you know, when I was entering them into our system, I was looking at roll value versus their opinion of value, and there was a certain percentage reduction. It was almost like, you know, in many cases, they were just taking the roll value and dividing it by 0.6 or 0.4 and entering a value just as a placeholder. So we don't put much credence in that value. It's when we start talking to the agent is when their true opinion of value shows up. At least Placer County's opinion.
Appreciate it. Thank you for going 3 for 3 on my questions.
Looks like you sparked a question here from our chair.
Well, I think Mr. Arias might have had something to add to those 2 questions as well.
I just wanted to quickly go back to the second question. And I think I got to tell you, I don't disagree that personally, I would be in favor of something like that. But I would also say that, it would have to be a standard that is for both parties, right? Holding the assessors also accountable, right? And as a taxpayer advocate, I got to say I wouldn't be doing my job if I didn't say that. To ensure that all parties are sharing information adequately in a timely manner, right? It has to be the same standard across the board.
And if there's a point, though, where it's so much staff time has gone into it, which equals taxpayer dollars that are being put into the process, and then the person coming in so late, it's like there has to be some type of cost analyst that also shows that government's losing money in this process, so it actually is not fair in a way either.
Right. Yeah, I agree 100%. And so in a perfect world, you send one request, and if it's reasonable, you get the information, right? And so I think that if we're in that perfect world and we're able to sustain that, it should be applied evenly across the board.
Correct, and it's like the equilibrium between a taxpayer that may be on a low income,
right,
being treated just as fairly as somebody that's wealthy and well-connected.
That's exactly right.
So, thank you.
One last question, one that I actually asked of the first panel as well on the simplification. And that is, to what extent would Prop 19 justify a reevaluation of the appeal application forms sections to assist taxpayers in completing the form more efficiently? What's your take on that? And I see our chair nodding her head.
I do agree with that. I think a lot of us have seen an increase in appeals that have to do with family farm applications, that have to do with intergenerational transfers. And in my county, we've been having a lot of farms that have been held in LLCs that are trying to transfer now, and they don't qualify because it's a legal entity that's trying to transfer, even though it's a family ranch that's being held in an LLC. And so challenges to that, and unfortunately, that's, code and interpretation. But I do think there is a place to put that. It's hard because you're back to tax jargon and verbiage. And, do people understand? You just put a box for Prop 19. Do people understand exactly what they're appealing? You're kind of back at square one. There definitely should be a space to add for Prop 19 issues, but it would just be clearly defining those issues.
Yeah, I did. So I got to tell you about 90% of the work that I do is surrounding Prop 19. And I think it's, there isn't enough information out there for taxpayers to understand that you have to move into the residence within 1 year. And so when taxpayers do circulate to say, hey, I want to file an appeal on this, it's not clear if they're filing a change in ownership appeal, if they're filing a new, clearly not new construction, but a change in so they're trying to figure out what this is. And so, one, I do think that there is enough out there now to substantiate a change for Prop 19. And secondly, I would say, there has to be more of an attempt to educate folks out there on some of the guidelines and restrictions of Prop 19. Right, we're heading into, what is this, the 5th year now? Yeah, and so people just don't know what it is. And when they come back to us, it's because they've gotten an escape bill. And it's way too late by then, right? Even if they did move in, but they didn't notify the assessor's office. So again, it's what are they appealing? How are they appealing it? Providing some clarity around that.
Yes, go ahead. There's a Vice Chair, go ahead.
Yeah, I was just curious, Assessor DePaul, in terms of family ranches and farms, are you seeing those broken up as a result of Prop 19? You mentioned like LLCs. So what's happening to those?
Yeah, so we haven't seen a lot of that yet. We've seen some very angry taxpayers and attorneys, because even the attorneys don't honestly understand it. And so we'll get some of the paperwork that goes with the sale, and there you can see that they're outlining that they predict that the base year value will be protected because it's going from father to son, but it's actually going from an LLC to the son, or from father to an LLC. And so we haven't actually seen, a lot of damage yet in terms of them breaking apart their farms or anything to that effect. We've just seen a lot of people that don't know how to appeal, don't know what to appeal, because they're so unhappy with what happened, but it's really just, it's the change in the law, and there really isn't anything to appeal. Do you know what I mean? And so it's difficult, and that's part of the process too, is that you should add something for Prop 19 on this form, but some of what people are trying to appeal there isn't a provision for it.
Okay, so are ranchers and farmers going ahead and pulling property out of LLCs and putting them back into a family owner or something, or?
So then you get into the matter of step transaction doctrine.
Oh, okay.
Yeah,
So the value's reassessed?
Yeah, so if you have it in an LLC and you take it out, put it in mom and dad's name, transfer it, and then put it back in LLC, if it's within a certain time frame, we condense all of those and ignore the middle. And nope, it went from an LLC to an LLC because the step transaction doctrine says that we have to ignore those if we can see that they are just doing that to avoid, property issues, property tax issues.
Wow. So if you're in an LLC, you're stuck. Right?
Yes, you'd have to be very, very conscious in your planning. And estate planning is really important for those farms and ranches that are held in LLCs, or any property that's held in LLCs that you're trying to do this with. Estate planning is really important.
Yeah, okay. Thank you.
I believe that Assessor
Is there any,
Fliger.
I was gonna ask, is so many hands I can't
Yes,
see?
she has her hand up.
It sounds like Lawrence Liu wants to weigh in.
I think it's Assessor Fliger again.
Oh.
Oh, maybe it is.
I do have my hand raised, but maybe
Yes.
Lawrence also wants to weigh in after. I wanted to go back to, on the Prop 19, yes, I think the calls we get here in Santa Clara County relate to Prop 19 more than any other issue. And I agree with President DePaul that sometimes there's so much confusion around Prop 19 that it leads taxpayers to file an appeal or take the wrong step. And so it goes back to the suggestion of making sure that taxpayers are able to reach someone to get their questions answered. Because our experience is most times when you're able to talk directly with a taxpayer and listen to their concerns, you're able to resolve it over the phone or in person. We wanted to go back on the scheduling question, Chair Gaines, just to reiterate the importance of the clerk of the board working closely with the assessor's office. And we really appreciate how in Placer County that process works. Whether or not the assessor's proposed schedule is immediately adopted, that's something we can work with our clerk of the board to figure out how that process works. But I think what's more important is that the assessor's office proposed dates be considered. And one of the ways you can avoid the appearance of a conflict or an appearance of prejudice to the assessor's office is the clerk of the board would still have the ability to take these proposed hearing dates from the assessor's office and vet them and ensure that they also work for the applicant. So it wouldn't be automatic that, the assessor's office proposes certain dates for hearings, and then the clerk of the board would just blindly and automatically schedule the hearings for those dates. But I do appreciate Placer County being able to schedule 6 months in advance and having that working relationship, because as we mentioned, we have limited resources like many counties, and I know every county has a different relationship with different stakeholders, but it's very important for us to have predictability in order to be best prepared for these hearings and not overburden our appraisers with 150 cases, which we have a real life example of, in a matter of a short period of time. That does not do justice for the county, the taxpayer, or anybody involved in the process if that's not well scheduled and everybody isn't prepared adequately for the hearing. And so we do want to ask the working group and the members of the board to please consider how we can move forward and make the rules stronger about how the assessor's office and the clerk of the board really need to work and collaborate better so that the scheduling of the hearing, we don't run too close to the statute of limitations, which was, as we know, would create other issues, but we create a schedule and a process that really works well for all parties involved, and so that we can have efficiencies in this process. Thank you.
Great, thank you, Assessor Flygor.
I wanted to answer Member Vasquez's question. Oddly enough, Los Angeles County has not had an influx of Prop 19 appeals cases. They're there, but I wouldn't say a majority of our ownership cases involve Prop 19. It's sort of a mixed bag. But our public service staff has had an influx of Prop 19 inquiries. Whether that will ultimately lead to more appeals going down into the future, possibly. But as of right now, at least based on the metrics that we've been getting from our teams, there doesn't seem to be an influx. But I do think that Assessor DePaul's point on expanding on the other issue category where you can fill out what the issue is, possibly even integrating the property owner's declaration form into the appeal where they can have much more space to articulate the issue would be helpful, because oftentimes it is sort of, we have to go weed through a lot of the facts that they present to us to figure out what the actual issue is. And sometimes it's not easily identifiable, and so it's not easily checked. So I do agree that possibly simplifying the form in a way where they can explain it themselves might be a way to go. Thank you.
Thank you. Seeing no other hands up there, I think we're good. I just wanted to thank all the participants, especially on this panel, and we'll come back hopefully soon with some recommendations, both from this board and with some of your suggestions to see if we can arrive with some consensus. And with that, let's move on to our next panel.
Member Vasquez, would you like to go out to the AT&T?
Oh, I'm sorry.
Just in
Yes.
case? As a note, we do not have any written comments on this item and no other additional speakers here in the auditorium. So AT&T moderator, please let us know if anyone is on the telephone line that would like to make a public comment regarding this item.
Absolutely. Please press 1, then 0 if you have any comments. 1, then 0. And no one has queued up.
Thank you.
Mr.
Yes.
Chair, if we could also take our labor break now?
I was
This
gonna
might be
ask.
a good time.
Is this a good time? So we can take, what, a 10 minutes, is that sufficient? So we'll do it 10 minutes, I got 2:05, so 2:15, we'll be back. Thank you. And thank you for those that came out from the panel. have, I guess our last panel here, we have, looks like both of our speakers here in person? I know Kata, I'm looking at somebody on the
I
screen
believe
here.
Mr. Waldman, you may come forward, and Mr. Middleton is on the remote.
Yeah, both of these organizations provided a valuable and practical, and AT&T is all wired up, right? We're ready to go. We'll give Kate a minute to come up to the front. Go ahead and take your seat. Our final panel here consists of taxpayers, organizations, representatives. These organizations have provided a valuable and practical perspective which rounds out our understanding of these issues. The first speaker of our third panel is Mr. Middleton from ProTax LLC, excuse me, who is also a member of CADA. We appreciate your attendance here today, and please go ahead with your comments.
Thank you. I appreciate the opportunity to appear before the distinguished board and to present some information. I will be wearing two hats today. The first hat that I'm going to be wearing is for James D. Pasquale, who's the chairman of the California Alliance of Taxpayer Advocates, who could not be here today because he is attending a hearing. So he asked me to appear in his stead and to read into the record his response to items 1, 2, and 3 that are particularly on this agenda. So with your permission, I will do that first. And then before I get into the item 1, I'd like to bring Mr. Waldman, who primarily can deal with item number 1 for us. And then I will deal with items 2 and 3, because I was working directly with Mr. Chris O'Neill and of course, Mr. D. Pasquale for CADA's response. But I would like to start off by saying my firm ProTax has been in business for 35 years. So I've been working with many of the assessors and board members that are present today. Many of you who are on the panel know me personally, and I'm very encouraged that we are communicating across all party lines, because several decades ago, there was no communication and we were doing a lot of things in the dark. So it's nice to see that we're all moving in the same direction. And so I'm personally very encouraged and I'm grateful to be here. So with that, what I'd like to do, with your permission, Mr. Chairman, is to just read into the record the words of Mr. D. Pasquale.
Sure, go ahead.
Thank you. So the letter is dated February 26th, and it's to the work group Chair Vasquez, State Board of Equalization from CADA. It's regarding the 2025 Assessor and AAB Board Work Group, Part 3, Items 2 and 3. Executive Summary. CADA surveyed its membership to understand the causes of delays in assessment appeal hearings. Contrary to the premise that postponements are primarily driven by excessive, quote, reasonable good cause, unquote, requests, our findings show that the main drivers are: 1, extensive use of Revenue and Taxation Code Section 441D information requests; 2, scheduling disconnects between clerks, assessors, and applicants; and 3, non-uniform administrative practices across counties. We recommend a standardized statewide pre-hearing process that requires assessors to first provide the basis for the assessment, limits information requests to relevant items, and clarifies timelines for all parties. These changes will reduce postponements, encourage informal resolution, and reserve evidentiary hearings for true disputes. Item 2, background. The SBOE's Assessment Appeals Manual emphasizes 2 core principles. 1, parties should have access to relevant assessment information. And 2, appeals must receive impartial hearings. However, practices vary significantly across counties, creating inconsistent taxpayer experiences and administrative challenges. Findings. 1. Postponements are not primarily caused by excessive, quote, reasonable good cause, unquote, requests. 2. Some counties use 441D requests broadly before providing an explanation of the assessment leading to delays. 3. Scheduling differences and non-uniform county processes create unnecessary confusion and inefficiency. 4. Some local rules raise due process concerns by closing appeals prematurely or without opportunity for reconsideration. And 5, many counties demonstrate that consistent early information exchange improves efficiency. Item number 2, good reasonable cause. The key issue is not the use of good cause requests, but the overuse and missequencing of 441D information demands. Applicants are often required to provide extensive documentation before receiving any explanation of the assessment. This can lead to, quote, non-compliance, unquote, designations that stall appeals. Recommendations include ensuring 441D requests are relevant, proportional, and preceded by assessor disclosure, avoiding indefinite holds, and adopting uniform due process safeguards. Item 3, scheduling coordination. A standardized pre-hearing model will resolve many issues before evidentiary hearings. The model would include 1, assessor's initial disclosure of the assessment basis. Number 2, targeted information exchange limited to the issues in dispute. Number 3, a pre-hearing conference with the taxpayer, assessor, and clerk. Number 4, a scheduling order documenting deadlines and the hearing date. And number 5, evidentiary hearings only for unresolved disputes. Finally, the conclusion. CADA urges the board to adopt a uniform pre-hearing framework, clarify the use of 441D, and provide consistent statewide guidance. These steps will reduce delays, strengthen taxpayer rights, and support efficient AAB operations. So this concludes the letter that I'm reading on behalf of James D. Pasquale, who is the chairman of the California Alliance of Taxpayer Advocates. So thank you. And then what I would like to add, going back before I introduce Paul, is my firm, ProTax, has been filing appeals since 1990, primarily for commercial between 2 and 50 million and residential. So much of what is being proposed here today is focusing on pre-hearings and a lot of stuff that has to do with larger property owners. The small property owner and the residential property owner oftentimes get overlooked. I'm grateful to see that in most counties, the assessors are very, very ardent and very interested in making sure everyone gets a fair hearing. But what my experience has been, when you have to do pre-hearings for every single property, and let's say you have just a bowling alley that just doesn't have much, or a fast food, there isn't a whole bunch of information other than comps and some certain relevant things. So a pre-hearing for these property owners makes it almost impossible for them to get a fair assessment hearing. So I'm just bringing that up because that's been who I've been representing for a number of years. So with that being stated, I would like to call Paul up to address item number 1, which is the thing that we're very much in favor of, which is the online signature, the electronic signature. Thank you. And I can, of course, take questions when it's all said and done. Paul, are you ready to come up?
Before I let Paul start, I was going to ask you, Michael Middleton, if you could, what you just read, are we able to provide that in writing so we could include it in our document?
Yes, sir.
Thank
Not
you.
only will I provide it, but I will also providing we did this survey amongst our members, so we will be providing examples from, by redacting whatever, because we don't want to have any problems with any counties. We just want to give examples of some of the problems that we feel should be addressed, to a proposed uniformity. So those will be coming, but yes, this letter will be presented to the board by CADA, along with some other information shortly after this hearing.
Thank you. Go ahead. Paul Waldman here, I guess, the Director of Ryan Services and a member of the California Alliance of Taxpayer Advocates.
Thank you, Madam Chair. Thank you. There you go. Thank you. Appreciate the, want to thank the CCBSA as well as the assessors who are all participating in this process and have really put a lot of work into it and provided a lot of great information. Really, a lot of what I'm going to say is what they said. I appreciated much of what they had to say. Mr. Middleton mentioned the e-signature. That's really not item number one, but it was something that was part of this, and I did want to mention a couple things. It was brought up a couple of times. I know that I think it was the Santa Clara clerk mentioned it, and a couple people mentioned it, and we still would like to see a more consistent e-signature process across the state. And I also want to thank Mr. Young for putting out the LTA just very recently, addressing that as well. But back to kind of more of what we're here for today, which is the item one on the agenda is the application. And in our previous documents that we submitted on this issue, Kata had mentioned the idea of adding an additional residential form, and we're hearing the pushback from CCBSA in particular on this. Their complaints were twofold. One was that it would maybe add more confusion by having more documents. With regard to that, I don't know that that would necessarily add confusion if you just had a residential form and a commercial form. Their other argument is that it could be potentially expensive and difficult for them to implement. Some of the various counties, particularly the ones that would have more financial difficulties in implementing the changes. And I certainly get that and understand it. It seems like the consensus among everyone else is really to focus on the form itself and change it. And clearly we're mostly talking about sections 5 and 6 of that form. And we would certainly agree that I've been doing this for 30 years, previously for the assessor and now on this side. And I certainly understand that form very well, but not many people have been doing it as long as I have, and it is all jargon, right? And so I agree that there should be some workshopping on that to add some more plain language, and I would agree with most of the comments that were said on that. The one particular thing on the form that I really wanted to talk about was the claim for refund. That's been brought up a number of times. And right now it's just a checkbox on the form. And there's a number of issues with it, one of which is that it seems to be ignored by some counties, and they require still an additional claim for refund. I would think that one very simple addition to the form, and this is just me personally speaking, is if we were to add, instead of not just a checkbox, but also the name of the entity that's claiming the refund, that's maybe paying the tax. I think that would be helpful. Mr. Parker mentioned that over time this can change, the entities can change, and that's true. We have a number of issues with that. And it's been mentioned that it really is sort of the obligation of the taxpayer to update that. And that's obviously correct, right? I mean, the assessor and the board would have no idea that those things have changed. And so it certainly is up to the taxpayer to keep that updated and to update the assessor and the board and the auditor, right, on this in order to get that refund out properly. But I think having that starting point of who that claim should go to, who that refund should go to on the form at the time of the application would solve a number of issues. Number one, 80% of the time, that's where that refund is actually going to go. Maybe 90% of the time, right? And on those occasions where it's different, it would be helpful to know where it was supposed to go originally, if it's going to change. Oh, look at that. We've got a new on the application 2 years ago, we said it should go here. We now know that it should go here, right? So that I think gives us a reference point for, even for the taxpayer itself to know, oh, I got to update this. I got to make sure we get that corrected. And then the other issue with regard to refunds is that many of our clients use third-party services to pay those taxes. And often those refunds go back to that service because they paid the tax. But they paid it on behalf of the owner. And when it goes to that service doesn't really know what to do with it, and it gets lost. And that's really the biggest issue we run into with regard to refunds. And so I think that having that name of the entity of where it should go on that form, along with the checkbox of the claim for refund, I think would be very, very helpful. That it goes back to the owner and not to some third party that paid it on behalf of them. So that's a little bit of my rant on that. I will also mention, and this probably does veer more into rant than helpful commentary, but if we're talking about simplifying things for the taxpayer with regard to the application, exorbitant fees are maybe a little bit of an issue as well. There are some counties that have really exorbitant fees to file an application. And I just literally got an email about an hour ago that another large county is adding significantly large fees. It looks like it's almost $300 per parcel for residential and almost $700 per parcel for commercial. If I've got a commercial property with 20 parcels, that's a $14,000 appeal fee. And if the assessor was wrong and we were right in filing the appeal, why are we paying $14,000 in a non-refundable fee to ask them to get it right? Maybe a little out of the purview of today's conversation, I don't know, but I thought since we're talking about applications, I would bring that up.
For context, how much was it before?
I'm sorry?
How much was it beforehand?
I'm not sure. I don't recall offhand on that county, but it was significantly less. Counties, a lot of the counties have fees of, $25, $35, $40, $50. And that seems reasonably fair. And I believe it is in the statute that they have a right to charge a fee to recover their expenses, right? At what point does that fee go beyond covering their expenses? I find it hard to believe that it costs them $700 to process a single parcel application. So hopefully I didn't derail things too much here. So let's get back to today's agenda. Number 2 was good cause. Most of what I have to say is, again, what they said. Most of the speakers mentioned that, some updated guidance would probably be helpful, but it should definitely be discretionary. There's a great deal of fluidity involved in that. My friend, Mr. Martin Arias, had a good comment. He said that it really has a lot to do with the information exchange, right? If the applicant needs to provide additional information or they need information, that's often where I'm requesting reschedules is, hey, and sometimes I got the information to the assessor pretty late. They don't have time to review it, so I'm requesting a reschedule so they have time to review it. Maybe we can resolve this without a hearing. So clearly there should be some discretion left, but guidance is probably not a bad idea. Mr. Wertz, I mentioned earlier that they tend to favor a reschedule because they tend to favor due process. And I do think it's very important that if we do talk about good cause situations, that due process is kept in mind there as well, for sure. And there are, as Mr. Middleton pointed out, there are some counties, it's pretty rare, but there are counties that have abused that a little bit and had denied hearings in a situation where it really denied due process. I would say that I do think that is fairly rare, but it does happen. And that certainly should be addressed in that process as well. With regard to scheduling, item number 3, first comment I noted that Mr. Parker had mentioned that it's important that the board gets all of the information so that they don't make a bad decision. And a lot of the continuances are based on that. Now, certainly it can be someone didn't provide it and should have, but the board does need a decision. The assessor needs a decision to do a proper evaluation. We sometimes will need information from the assessor to understand how they assessed it. So I apologize. That actually is part of number 2. That's part of the good cause issue. I put that in the wrong area. With regard to scheduling, I will say that the CCBSA submitted a document, I believe it was yesterday, and they had a lot of really good comments on this. I would echo a lot of what they said there. It's important that scheduling obviously needs a lot of work. I think everyone agrees this is why we're talking about it. It is important that it doesn't prejudice either party, especially the taxpayer. Some people, there was a proposal of the assessor proposing hearing dates. And I would certainly be wary of that. One of the issues that we've run into, and we have specific examples of it, is forum shopping on the assessor's part. The assessor will sometimes have a board that is more favorable towards the assessor, and they tend to steer some of the cases towards that board. So when it comes to any work on improving the scheduling, it's important that that be kept into mind. And it's been brought up certainly by the CCBSA, and I think even the assessors have mentioned that. I forget which assessor it was, mentioned that and talked about maybe at least having the applicant a chance to respond and confirm on a date. And that would certainly help in that area. One thing that I think would be helpful with regard to pre-hearing, and this is very important, this is kind of a difference between what Mike Middleton runs into and what I run into. I deal a lot with larger properties. And so one thing that might help the scheduling and when it comes to larger complex properties is a more robust use of pre-hearings. And I want to take this opportunity to mention, and I want to thank Assessor Marks. He literally I think it was just this week, put together a meeting of all the stakeholders to talk about the appeal process in general, including scheduling. And if I recall correctly, I think someone mentioned to me they talked about making greater use of pre-hearing conferences to improve their scheduling. And so, Assessor Marks is certainly putting some additional work in this and doing it in a very good way with bringing in all the stakeholders. So I want to thank his office for that. I do think that by using the pre-hearing conference, you could improve the scheduling for larger complex cases, right? You can, at that pre-hearing, you can determine scheduling that will work for all parties, and that would help a lot. I do think it's important to caveat that with not overusing the pre-hearing conference with smaller properties. That's really an undue burden, I think, on the smaller taxpayers to have to kind of get dragged in front of a board as someone mentioned, I think it was, I think Assessor Marks, Mr. Arias mentioned, San Diego has morning sessions and they have afternoon sessions, right? Most counties do. You're there all day, and when you come up, and you got to take your whole day out to do this. If you have to do that for a pre-hearing as well, then that really gets onerous for a small property. But I do think it's beneficial for a large property. And also, our member, Chris O'Neill, has mentioned that can also be abused, right? Where they have serial pre-hearings, where the assessor's demanding information that we don't feel is appropriate to turn over. That's really for the board to decide at the hearing. So I think pre-hearings should be minimized. Really should be able to handle most of it in one, unless both parties agree that maybe there's a reason to have a second pre-hearing. But I do think it would be important that both parties are in agreement on that. Otherwise, I think from there you need to go to a hearing. I think that's really all of my comments. Mr. Middleton, did I say anything that you want to add on to there?
Yeah, as a matter of fact, you did. So I would like to, can you hear me? Did I mute myself?
Yes.
Okay, good. I would like to address, so when I started my firm in 1990, there was no filing fees, there was no hearing fees. And I think the reason back then was because the whole idea is when an assessment gets made, the applicant has a right to just find out why, and then either do informally or formally find out from the assessor. And so what we're seeing now is most assessors are equally willing to do that. In LA County now, they don't even have pre-hearings. They schedule most of the hearings. And now, since we're able to do things remotely with technology, we're able to represent a large number of our clients who otherwise we couldn't, because it would be cost prohibitive for us to go up there or fly up there, with today's travel costs and everything. So technology has obviously made it a lot better. But the hearing fees and the filing fees are something that we've fought, way back in the 90s and in the early 2000s. And now they're going so fast that a lot of property owners, let's say you have a fast food chain or a bowling alley or any kind of car wash, which we represent a lot of them, they won't be able to simply afford those fees, and they just won't file the appeal. Like they'll just tell us, forget it. Like, we're just not going to do it. So the other thing I wanted to talk about was section 5 and 6 of the appeal form. There was a lot of great recommendations. I know in the past, even we've had difficulty with determining which county, whether or not to include a copy of the supplemental bill or the tax bill or the notice. So, there's a lot of confusion. And I noticed that even many of the previous speakers from both the clerks and the assessors both said that form, especially those areas, could be enhanced. And I agree with that. I think that, as part of the recommendation, making it clearer and easy to understand what is actually being appealed and what is required would be nice to know as well. So those are the two things that I wanted to add to what Paul has to say.
Well, thank you. Thank you both for your comments. As I mentioned earlier, the taxpayer's perspective is critical, and especially for the representatives who handle more complex appeals. I have a couple of quick questions that I asked the previous speakers, and then I'll open it up to the members as well. And you kind of touched on it a little bit, Mr. on the refund. On the question of whether the BOE can add refund information to the appeal application form. And in your experience, working through this, where do you think the impediments or concerns on the refund process might be?
So what we found is,
go
I'm
ahead.
sorry, I'm here for Paul.
Go ahead.
Okay, I'll start first. So what we found is Paul has a lot of larger clients that actually pay the refunds through a management firm, and that's where we found it. Where we found the problem is when the client has either a property management firm or whoever paying the bill, and then the counties will just refund the money to whoever paid it, which makes perfect sense, but it's not really the owner. So we have to chase down the title company or whoever has the refund in order to get it back to the owner. So if there was something on the form or that just says, this is the entity that's responsible for paying the tax and who the refund should go to, like, I don't know if there's a place we could put that, that would be great on the form, but I know it's hard to change the form. So we've basically just chased it down, which adds a greater burden. And as far as the refunds themselves, that is being fixed a lot. A lot of credit goes to LA assessor and San Diego County assessor, as they've been doing a lot of good work on working with us through CADA to actually process those refunds, which sometimes can take, I think we've had some that actually took over 2 years to get because we had so many cases going through. But LA's done a great job of updating their systems, working with us, and actually getting those refunds out to the clients. And that's been greatly appreciated.
Yeah, I'd like to second what Mike said there. Both LA and San Diego are really, have improved that quite a bit, or LA's improved it quite a bit, and San Diego is quite good. Yeah, as I said, for me, the biggest issue, there are two issues. The biggest issue is when it goes to that third party. Because the bigger problem is that the third party just aren't good at figuring out what to do with it. And so when we call them up, they can't find it. They don't know what's going on. They don't know how to find it. They don't know how to get it back to you. And it really shouldn't have gone there in the first place. They're just a processor. The money doesn't belong to them. And so that's really, I think, the biggest issue. The other issue we do have is when there's a name change, a company, sometimes it can be very difficult to get them to reissue it to a new entity. And I don't know that there's a simple solution to that because they do have to be careful, right? You can't just have somebody coming and saying, oh, no, that should go to Mr. Jones, right? I don't know if there's a simple solution for that other than, as I said, one thing that would be helpful is if, 2 years later, we're looking at the form and go, oh, that name is, we have the name on the form of the entity, and we see it and say, we need to change that before we get that refund issued. And you can proactively do it before that they try and send out the refund to the wrong party.
Thank you. And on the simplification, a similar question I asked for the two panels before is, to what extent do you believe that Prop 19 would justify a revaluation of the appeal application form sections to assist taxpayers in completing the form for more efficiency?
I don't really have a good answer for that because I don't do much Prop 19 work. I haven't done one. So that's not something I deal with a lot. Mike, do you deal with that at all?
No, I really don't. Prop 19 hasn't come a whole lot from my clients. It's mostly Prop 8s and Prop 13 issues. And so, no, I don't have anything to add on Prop 19.
Yeah, sorry about that.
No problem, thanks. I thought I'd ask. With that, let me open it up to looks like the Deputy Controller has a quick question. Go ahead.
Thank you both for your very nice and concise presentation. In regards to topic 2, good cause standards, counties have asked for clearer frameworks to avoid automatic continuances. Would you support guidance that clarifies standards but preserves discretion?
I'll go ahead, Paul.
No, you go ahead.
Yeah, I certainly would. There is legal frameworks that obviously have to be followed that have legal precedence for good cause. But there certainly would be we would definitely be interested in working together with the panel to come up with good guidance so that there aren't, like was mentioned earlier, someone wanted to go golfing or something. Yeah, it has to be, if you're sick or there's, other standard things of information that hasn't been presented or hasn't been received, but then it's presented at the board, then yeah, there's definitely good cause that should be clarified. So we would support that kind of guidance, and we would put our input on it as well before it goes forward.
Okay, great.
I would echo those comments.
Please.
I would echo those comments and just, as long as, certainly guidance would make sense. as long as due process is also being considered as well.
Appreciate that. And then in regards to topic one, counties argue that the main issue is instructional complexity, not form length. Do you agree that plain language resources may be more effective than new forms, which may cost and be time, may cause a lot of time and resources over the course of a year or two to get those new forms going?
I think it makes sense, just putting on my sort of taxpayer advocate hat. As I said, in our industry, right, we're experts, right? So I don't have a problem with the form. I understand the form inside out, upside down. And I can make it work however I need to. It's really for people who aren't familiar with the process, which I think is primarily residential homeowners, right? Or very small commercial owners who own a building or two, that kind of thing, who don't deal with this process on a regular basis. That form doesn't make any sense. It makes perfect sense to us who've been doing it for 30 years. But in lay terms, it's gibberish. So I
Yeah.
do think that somehow putting more plain language in there would make some pretty good sense.
Over new forms?
Well, as far as new forms, are you referring to what I was saying earlier, where maybe a residential form? I personally think that having a residential form and a commercial form would make sense. I think it would be simple enough to identify which form you're doing. But again, I would, on that, personally, I would defer a little bit more toward the CCBSA, who has to deal with it, more so than I do. And I understand their concerns. But I do think a residential form makes sense.
Appreciate
And
that.
I'll speak to that because we file probably more residential appeals, than almost all agents. And we really don't have a problem with the current form. I do think sections 4 and 5 could be clarified as far as the instructions. And again, with the CC talked about earlier, BSA, they did a really good job of enunciating, what could and couldn't be. And I know that like LA County, they have, it would create huge structural problems for them to incorporate a lot of huge changes to the form. So I'm not a big advocate, personally, speaking from ProTax, of changing the form a whole lot. I'm more interested in the process of, making sure that all applicants get in front of an evidentiary hearing, regardless of, whether or not what information they've submitted. That's very important. But they should be submitting whatever information they have. But I'm not a big advocate for changing the form just to change it. Some of the smaller changes they're talking about would be very, very beneficial.
Thank you.
I think LA would probably be a good place to talk about this, because they did change the form completely, right? They used to have this big form that was an LA County only form. It was a triplicate. Remember the old carbon copies? They had the salmon copy and the yellow copy and the white copy, and they changed their form completely to match the BOE form. And so I would say LA is probably pretty familiar with what it would take to change the form.
Appreciate that. And then my last question, just so I hit every topic 3, would transparency reporting on hearing assignments alleviate neutrality concerns?
I'm sorry, say that one more time.
Would transparency reporting on hearing assignments alleviate the neutrality concerns?
I'm not sure what you mean by transparency on hearing assignments.
As in, like you mentioned about the forum shopping earlier?
Uh-huh. I'm not sure how that would look or how that would be implemented. A random thought that occurred to me while I was thinking about this earlier is, I guess, like I know in certain counties, there are certain members on certain boards, right? So in this one particular county where I know that there's forum shopping, there's this particular board that the assessor likes because they get favorable decisions. And that board meets on certain days. And so they're never available on the other days. They're only available on that day. right, when it comes time to rescheduling a hearing. And that's how they get onto that board. So maybe if the board members were randomly assigned to different boards, that would really, I think, eliminate a lot of the forum shopping.
I appreciate that.
And I'll take a stab at that. I don't think there's a whole lot of board shopping going on. It's just, I've done this 35 years and I've seen it come and go. So to actually implement something where you have to report would just require a lot of good people's time, both at the clerk's and the assessor's office, because most of them are actually very interested. I've found both in the assessor's offices and in the clerk's offices to do a good process. So requiring reporting on that just to ensure it, I don't think it's necessary. I think it could be counterproductive. So I wouldn't support something like that because I think those things have a tendency to be discouraged within the offices themselves when they find out about them.
Absolutely. So definitely not a trend that we're seeing. So
Yeah,
Correct, sir.
appreciate your time.
Correct.
If I can make one more comment on that, and echoing a little bit of what Mike is saying, I want to be careful. When we talk about stuff, sometimes I think we gloss over a little bit of what the magnitude of these different things we're talking about. And yeah, I don't think forum shopping is a common thing. I don't think all the assessors are out doing it. I personally know of one instance, and I've heard of another. So I know that there's a couple counties that are doing it a little bit to some degree. I wouldn't say it's a major issue, and I don't want to paint the assessor community as doing this. That said, it is where it is happening. I think that's a major problem, right? That really should not be happening, and it's a problem. But I do think it is minor in the amount that it's happening.
And if you do,
And I think it's actually
identify the
being
type of
addressed
case,
internally.
do you report that to the State Board of Equalization or another entity?
No, we just deal with it.
Got it.
We accept the loss and move on. I mean, I don't know what you do. I suppose we could try and report, maybe you can report that, I don't know.
Maybe a hotline
Yeah,
or something.
Yeah, right.
We look at it the same way. You win some and you lose some. That's just the way it is. The assessors would win some and lose some too. We all do. So we just move on unless it becomes systemic, which I don't see that happening right now at all, especially with this forum that we're all engaging in where everyone is coming forward and working to pull in the direction of the taxpayer and fair assessments. I think it's harder and harder to do that kind of stuff in today's environment because you will be caught.
Yeah, maybe one option is we can try and talk to the Board of Supervisors in the county where we see that happening. I know we have a particular county that we've had some real issues with, and we've done that. We've had meetings with the Board of Supervisors there. Maybe that's the solution. Unfortunately, I don't have good solutions. I'm just reporting the problem at this point.
Appreciate you. Appreciate both your time today. Thank you.
Yeah.
Thank you. It looks like Vice Chair has a couple questions for you.
Yeah, thank you. I just wanted to address this issue of high fees. And do you have a solution for addressing that? So if a particular county has fees that appear to be out of line, I mean, how do you handle that?
I don't know.
I can tell you how we handle it. I mean, right now, we just have to pay them. And so what it does is it has a huge chilling effect on many of our clients because, I didn't hear about the new one that Paul just brought up, but, when, my firm initially opposed the filing fees 20 years ago. And once they started, and you're right, it does stop companies that are out there that are just doing filings without ever potentially showing up at the hearing. But it also puts a major chilling effect for those, legitimate taxpayers, both homeowners and small property owners, to actually file. So the filing fees and now the hearing fees, I don't know what we can do about it. Right now, unfortunately, we're just paying some massive fees in counties and trying to pass them on to our owners who really don't want to pay them. I mean, our clients.
I mean, I don't know, is that maybe something within the Board of Equalization's overview, of the assessors purview, I don't know, to kind of review that and to deal with out-of-line fees? I don't know. I don't know how we would deal with that. The way we deal with it, as Mike says, is we pay the fee.
Okay. Could I ask a question of staff for clarification in terms of, do we have authority or not?
For the record, David Young, Deputy Director of the Property Tax Department. I will have to take a little bit of a look into it. I know the counties are able to recover fees for processing the application. But I'm not that familiar with that provisions of the code, since it falls within something outside of the county assessor's purview.
Have we done a letter to assessors on this issue, or is that something that would make sense? I don't know.
Not to my recollection.
Yeah.
Not to my recollection.
Okay. But maybe that's something that you could report back to us, just so we know.
I will take a
Yeah.
look at it, of course.
Sorry, Dave. Wonderful job. It's not the assessors that oppose the fees, it's the clerks of the board.
Okay.
And they're getting approval through their board of supervisors. We have no authority.
Okay. So an applicant would have to sue the county or speak to Howard Jarvis,
Yeah. that's a
someone
good
like
point.
that.
It's not the assessor.
If the fees are
Yeah.
onerous, right? Yeah.
Yeah,
Okay.
we did that. There's a case law in San Francisco where Protex actually sued the county of San Francisco when they tried to implement the filing fees years ago, and we lost. So then it just kind of spread, and we just kind of absorbed the fees, or we send letters out to all of our clients saying, this is the filing fee, and we try to get them to pay it. Some do, some don't. So if we think there's a case there, then we pay it.
Yeah,
Well, we had, yeah.
I personally don't have an issue with filing fees in general. And most counties have a reasonable fee. I know it's harder for, Mike's clients, my clients, it's not a big deal. In fact, we absorb it. We generally don't bill them back because it's probably more expensive for us to try and collect that extra $50 from each client. But when you start getting these exorbitant fees, particularly, and my biggest issue is when they're per parcel, right? Because, is it really that big a difference to process a 1 parcel application or a 20 parcel application? And in this example where if it's $700 per parcel, that's $14,000 for 20 parcels. And is there any world where it costs them that much to process that application?
Right. I know that I'm familiar with the Sheets versus El Dorado County decision for where the applicant was actually trying to build on a parcel. And so the building fees were out of alignment with the actual usage of the applicant. And the Supreme Court ruled in favor of the property owner. And so it was my impression that counties and cities have to, it was further evidence that they had to make sure that they could justify their fee, right? So that you just can't charge an arbitrary fee. It has to align with the actual cost.
Yeah.
So maybe that would be the pathway that someone would have to go through.
Yeah, I mean, you'd have to be dealing with something where there's a lot of money involved, because it would be a legal issue, and there's very little opportunity, very little situation where the money would be enough to cover.
You probably have to get someone to help you.
Yeah,
right?
you got about 5 hours worth of lawyer time and you're done
Yes.
there. I will add that we had a case in Hawaii where we had to spend $40,000 a year on filing on a timeshare. So I mean, these things, they happen, but.
Wow, okay.
I'm glad you brought that timeshare up, because one of the largest reductions that my firm ever got was for a timeshare here in San Diego County about 15 years ago. And it was covered multiple years. And if we had to pay a filing fee, that reduction never would have gone back to the client. And it was just one property with a bunch of, could have been apartment units, but they turned it into a timeshare. So it was a very nice property. But they were assessing each week individually. So you had literally hundreds of parcels. So there's no way it could have ever been appealed at all if there had been individual filing fees per parcel on that one.
Yeah, interesting. Okay, thank you.
Thank you.
Seeing no other questions, the last one I was just going to bring up on and I think you kind of touched on it, the AAB scheduling coordination. We've heard perspectives on this issue in addition to the perspectives of county clerks and assessors, to the extent that additional BOE guidance could encourage the categorization of appeal applications by complexity. Do you believe that this would be helpful in facilitating the efficient scheduling of appeals, the hearings?
Yeah, thank you for bringing that up. I meant to comment on that when I heard them talking about that. Yeah, I think that would make very good sense. If you can categorize them into quick, easy hearings, something in between, and very complex hearings, yeah, that would make a big difference, I would think.
Yeah, and I'll speak to that. Basically, what's happening now is a lot of counties, especially the clerks, they're trying to figure out, when they get all the appeals filed, many times we'll get 100 appeals scheduled on one day. Obviously, that'll never go forward. So they either get continued or that kind of thing. But I will say that each one of the clerks in the separate counties, because there's LA and then there's MODOC, and it's such a different thing. And most of the counties are working very diligently, especially with us, to they're actually reaching out to us at some point and asking us, because we've been working with them we have, personal relationships with some of these people in the counties. And so I think putting guidance out would be difficult because, you've got LA County and then you have all the other counties in between. So I wouldn't know how you do that, to be honest with you.
Yeah, and I've run into situations where, a scheduling issue, another issue is like, I have a client with an economic unit of 7 parcels. And I think several times now, they've scheduled 3 of the parcels, then they scheduled 2 of the other parcels, and then 4 parcels, and we've yet to get all of them scheduled in the economic unit. That's one issue. Another issue I have is I've got a client where it's a hotel with real personal property and intangible property, and the assessor insisted on, and the board agreed to, that we hear it all together, the personal and the real. And then they rescheduled it with the real and the personal separate again. And so there's a lot of, I think, I don't know if that's just individual clerks need to figure out how to coordinate within what they're doing, but that's an issue as well within scheduling.
Well, thank you. And thank you to both of you for sharing your thoughts and ideas and giving us some suggestions and ideas as we move forward. With that would conclude this panel. I'm going to turn it to Ms. Taylor to see if they have any written comments or anybody on the line that wants to give public comment.
Thank you. At this time, we do not have any written comments, and I don't believe there's anyone in the audience that wanted to add anything on this particular panel. AT&T moderator, please let us know if there's anyone in the telephone line that would like to make a public comment regarding this item.
On your telephone keypad, 1, then 0. No one has queued up.
Thank you. With that, I want to thank all the participants we've had this morning, both remotely and that have made the trip to come here personally. And also the members here for sticking it out with me today on this issue. And I know we've been we've been going back and forth, but it sounds like we got some good information and some good feedback to hopefully come back with some consensus recommendations that we will share both with the board and the participants and see if we can't move this a little bit further and at least on some of the critical issues have some movement. And really, we're looking at probably, hopefully, maybe the April meeting, to see if we can get something back to everybody and see if there's consensus, not only from the board, but also from all the different stakeholders that participated. With that, I would like to just turn it over to any of my members for any closing remarks before we shut this down. And I see my chair, go ahead.
Thank you. Well, I wanted to thank you, Mr. Vasquez, and your staff as well for coordinating all of the valuable input that we've had here over 3 meetings. And I'm struck by how much convergence there is around certain ideas. And I think that we can suggest some good ways to improve the system so that there's less friction in it, both for the assessors, the advocacy community, the taxpayers, the clerks, and others. So thank you.
Thank you. Deputy Controller, Armand, go ahead.
Thank you, Mr. Vasquez. Really appreciate you and your entire staff for
Bless you.
putting this together. The controller and I both really believe this is a very important issue, if not the utmost important issue. And we're looking forward to working together to find solutions. And it's very important that we get this all on the record as we chart a path forward. So thank you all again, and looking forward to our next steps.
Vice Chair.
Good, can I just summarize a couple of
Sure,
points? Is
go
that
ahead.
right? Yeah, this
This is
is
the
a
opportunity.
great hearing, so thank you
Thank
for
you.
that. And I thought the input from everybody was really high quality, so appreciate all the participation. And just a couple of things that stuck out for me had to do with the clerks, with the quasi-judicial issue with an administrative hearing. What I was able to glean from that is that it sounds like the clerks are in charge. That's my sense, and they need to work with assessors though and cooperate with them in terms of scheduling these AAB hearings. And I thought there were some good recommendations in terms of how we could improve the assessment appeal application. Things such as a preferred method of contact, maybe a box defining the relationship, the claim of refund. I thought those are really great points. Another one had to do with Section 8, and you may win the AAB hearing, but you may not get the refund. So I think that raises some interesting issues in terms of clarifying where the refund is going, and then more good information, suggestions on a contact phone and email on the application. Good cause definition is a good path to go down. I like this idea of a schedule with days allocated for each step. How to deal with repetitive appeals, excuse me, and the name of entity. I think would be important too to have on this assessment appeal application. And then I'm wondering if on our information sheet, can we define some of these terms? Because if you look at contracts, they usually start out with definitions in a contract, right? Now, this is an application, but it's not an easy application, and the practitioners understand how to use it, but just the common individual that wants to make an appeal struggles with it. So I know you're going to be making this information sheet longer, but I think some definitions would help. And that's it. But I think we have a lot of progress today, so thank you. Appreciate it.
Yeah, thank you for your remarks. Like I said, the goal is to try to get something back on our April meeting. And I know our next meeting is coming up on March 25th. And that, we might get a teaser out by then, but hopefully by April, we'll have some of these issues that were discussed today where we feel there's a consensus, and share it with the board And depending on what feedback we get from you and the stakeholders that participated, we'll see how far we can move this thing and how quick. Thank you again for all those that hung in there with us today from the beginning. And wanted to thank staff, Ms. Taylor for her assistance on this. Of course, my staff for making sure we had all the folks come out, both remotely and in person. And it's coming up, actually, we were pretty much on target. I was surprised. I thought we were gonna run a little later, but and we're coming up on 5:21 on this. So with that, this will officially adjourn this hearing, and we'll reconvene as a board on March the 25th, 2026. 15:22? Okay. Yeah. All right, thank you.
Thank you, honorable members of the board. Really appreciate it.
Thank you.
Thank you.